What's up guys, Acerthorn here, and today I'd like to regale you with a blast from the past. Yesterday, I put up a video explaining that I had lost my harassment and doxing and copyright infringement cases. I mentioned that the judge didn't throw the case out for legitimate reasons, but simply because he didn't like me, and because of judicial immunity, he's allowed to just be corrupt like that. However, I didn't actually expand upon the idea of judicial immunity or explain just how deep the rabbit hole of evil actually goes. So today, I would like to provide an exceptionally in-depth look at the scope of corruption in the US government. 5 years ago, in the summer of 2017, I made a video that was nearly 6 hours long that provided an exceptionally in-depth look at corruption in the United States. It was originally posted on a different YouTube channel. Today, I'd like to share that video with you. Now, you're going to notice a severe lack of quality editing in this video. This was one of the first videos I ever published to YouTube, and I didn't have very good editing skills at the time. Some people would argue that I still don't have very good editing skills, but that's beside the point. Basically, if you go and watch my first ever video game story analysis video, or the Stormcloak's Racist, a video I made when I had only a measly 7 subscribers, you will see just how far I've come. My talking was very, very slow, and my edits often looked butt ugly. That's the kind of production value you can expect to see from this old 6-hour-long video. In any event, I hope this video will explain to many of you why, if you end up pissing off whoever happens to be in power at the moment, you don't have any rights at all, even those that are explicitly stated in the Constitution. This video is 6 hours long, not because I was repeating things ad nauseum, but because I needed that much time to properly cover everything. Well, that and the fact that I was talking really slowly because I was still very new to reading off a script, that too, so maybe you might want to increase the speed to approximately 1.5x speed or something. Anyway, please forgive the lack of proper editing since I was still inexperienced. Also keep in mind that this video was originally made in 2017, so a lot of the things that I will say will probably sound dated, like when I say that 2016 is the most recent year for which full statistics are available. Obviously, that's no longer the case, but it was the case in 2017. One last thing. When it comes to sources, I originally made this video back when YouTube annotations were allowed. Annotations are no longer allowed on new YouTube videos, and videos which predate that change that had annotations in them can no longer edit them. Because of this, I repeatedly post the text saying, "click here for source," multiple times in the video. That obviously will no longer work. So instead, I am providing a link in the description to a Google Docs file where I provide timestamps for each source, as well as links to those sources. That's the best I can do for now. So, with that being said, we now move on to our feature presentation.
Well, here I am, sitting in this roach-infested apartment with no air conditioning broke off my butt. And I'm wondering why. Why do people not care? Wondering how. How did the government get so corrupt? Wondering what. What is it going to take to get people to rise up and reform this government? Why do people ignore the corruption in this nation? Do they just not care? Or do they just not believe they can do anything about it? Well, this video is going to show the people why they should care. It's going to show you how you could very well wind up in jail, not because you committed a crime, but because you got on someone's bad side. This video will show you how this level of corruption is not only common, but literally everywhere. on the level you thought only existed in dystopian novels. Instead of focusing on isolated incidents, except to help paint a picture of how bad the problem is, I will be focusing on statistics to show that the specific incidences I do show are the rule, not the exception. But this video is different than other corruption exposing works out there. I'm going to take it one step further. I'm going to show you how there is hope, and it doesn't require 40+ hours per week of participating in government on your part. I hope you will find this video informative, and its contents sufficiently infuriating. But more importantly, I hope you will find that there is a light at the end of the tunnel. After you watch this video, I want you to do a few things. First, I want you to share this with literally anybody you can. The more people who know about this problem and its solution, the better. Second, I want you to download this video using whatever download apps you can, and then re-upload this video to your own YouTube channels. The more viral this video goes, the more people will see it. Also, I fear that Big Brother might want to take this video down for reasons I'll get into in section 1-6 of this video. So if it's already uploaded to multiple channels, it will be exponentially more difficult for them to completely suppress this message. Before we get to the main part of this video, I want to take a minute to address what this video will not cover, so there will be no confusion going in. As I said earlier, this video will not be dedicated to exposing a handful of specific incidents of corruption. After all, that doesn't prove my case. Isolated incidents do not mean that the entire system is corrupt. For the most part, this video will cover more broad, general pieces of evidence, like statistics, double-blind studies, and actual laws passed by Congress or precedents set by major courts. With the exception of section 1-6 of this video, I will restrict myself to a maximum of 4 specific incidents per section. These specific incidents will be designed to help illustrate the points I have already made, not make the points in the first instance. Also, this video will not be dedicated to explaining the obvious aspects of government corruption. Things like how lobbyists can give gifts to politicians in the hopes of receiving political favors without any quid pro quo exchange, or how police officers will always be believed over citizens when a complaint is filed. Those things will be mentioned in this video, but I won't go into details about them. Frankly, I think government wants the people to focus on these obvious things, so it will distract them from the real problem. This video will be dedicated to exploring just how widespread the most blatant forms of corruption are, such as quid pro quo bribery, which is going to be a lot more common than you probably think. I also want to apologize in advance for any poor potential structure behind this video. There is a possibility that this video, and the pace at which it introduces evidence, might be a bit off. This was originally intended to be a book that I sought to have published, but then I couldn't find a publisher. We'll get into that more when we talk about section 1-6. Last but not least, before we continue, I want to take a moment to establish some rules of thumb. Accepting these rules as true will be critical to understand the points I make later in the video. Some of these rules of thumb might even sound like common sense at first glance, but I feel the need to make them perfectly clear at the outset, so I don't have to repeatedly go off on long tangents. Rule of thumb number 1. If the law requires you to do something, you must follow the law, even if you disagree with the law. Again, this sounds like it should go without saying, but you'll be surprised how often this comes up in this video, which is why I'm including it as number 1. When the law requires someone, especially a government official, to do something they don't like, such as giving a marriage license to a same-sex couple, which may or may not conflict with their religious beliefs, we shouldn't have to justify anything to them. The fact that it's the law is all the justification we should need. Again, this should go without saying, but you'd be surprised how often it doesn't. Rule of thumb number 2. If something hasn't been made illegal by the government, citizens should have a right to do it. Again, you'd think this would go without saying. If your state has no law prohibiting sexual intercourse between 2 teenagers younger than 18 years of age, the police have no right to stop those 2 teenagers from having sex with each other so long as nobody above the age of 18 is mingling with them. No exceptions to the law should be required. What should be required is a law stating that it is illegal, not an exception stating that it's legal. Again, this rule of thumb will come into play during this video a lot more than you'd probably think. Rule of thumb number 3. If a government official hasn't been legally authorized to do something, he cannot do it. This is basically the mirror opposite of rule of thumb number 2. With a few exceptions, usually involving emergencies or extreme circumstances, a government official should only be allowed to do whatever he has been specifically authorized to do. If you give a letter or package to the post office, with proper postage paid for and a valid shipping label, the post office cannot refuse to deliver the package for you except for those reasons which they have been specifically authorized to. This is in stark contrast with private carriers like UPS or FedEx, who can refuse to deliver packages for no other reason than they don't like you, and that's perfectly legal. If there is no specific legal authorization to do something, government officials are basically video game NPCs. In other words, you could drown them in a sea of watermelons, and they can't react in any way unless they've been specifically programmed to react. Now, before you flip your lid over these past 2 rules of thumb, before you start leaving hate comments about this or that hypothetical situation, let me temper these 2 rules of thumb with rule of thumb number 4. Just because something isn't illegal doesn't mean it can't be used as evidence. For example, it is not illegal, strictly speaking, for me to have blood splattered all over my wall. Look in the criminal codes of any state in the USA, you will not find a single statute that provides for any fines or prison sentence for the crime of decorating your walls in blood. Maybe it's my blood, and I just prefer a macabre atmosphere like the Addams Family. However, if a cop sees that bloody wall, he's still going to use it as evidence of something else going on that is illegal. At the very least, it's going to be used to start an investigation. Again, this almost sounds like it should go without saying, but apparently we need to tell a few government agencies that. Rule of thumb number 5. This is the big one. The one that's going to be the hardest pill to swallow up to this point. But I do mean this sincerely, though. Government corruption is the absolute worst crime that any person could possibly commit. The worst. In fact, corruption is worse than murder. Yes, that sounds outlandish at first, but let me explain. See, our legal system here in America is based on the common law of England. In English common law, the act of treason was considered the worst crime one of the king's subjects could possibly commit. It was considered to be the only crime that was worse than murder. And if you disagree with that, well, please remember rule of thumb number 1. We still see shards of that present in today's law, like how killing a cop or judge carries a worse punishment than killing a normal person under otherwise identical circumstances. Just to give you an idea of how serious treason is supposed to be under our system of law, the state of Vermont still provides for the death penalty for anyone convicted of treason, and yet it is still technically considered one of 19 non-death penalty states. However, this is the United States of America. We're a democracy. The people are supposed to be the ultimate sovereign. The people do not serve the emperor in this nation. It's the other way around. Or at least it's supposed to be. So when the government betrays the people, that should be worse than when the people betray the government. So corruption is worse than treason. So if treason is worse than murder, that means that corruption is worse than murder. But as we'll soon see, whether you agree with my reasoning or not is ultimately a moot point, because as we will soon see, government corruption often begets murder, even if it isn't worse than murder in the first instance. So with these rules of thumb out of the way, let's finally cut the bull crap and get to the stuff you came to see, the evidence of the corruption. Title 1. How bad is the corruption? A great superhero once said, people need extreme examples to shake them out of apathy. This rings most true when trying to get people to reform a corrupt government. As such, the first title of this video will be dedicated to explaining just how bad the corruption is. No state in the country, not even a single city, is exempt from the spread of corruption like cancer throughout all aspects of government. All aspects. Understanding the size and scope of the problem is the first step to coming up with a solution. Section 1-1. Judicial Corruption. Let's start off with an alarming statistic. If I told you there were an estimated 32,000 state and federal judges in the entire USA as of the time of this writing, and I then asked you to make an educated guess as to how many times each year one of these judges accepts a bribe, what kind of figure would you come up with? Go ahead and pause the video and come up with some sort of figure. Write that down and then continue watching this video and grade yourself on how well you did. I'll wait. Are you done? Okay. Transparency International, Yale Law School, and Seeker.com have all undertaken efforts to create a relatively accurate number. While their estimates vary widely, even the most generous estimates are astronomical. Transparency International has the largest figure. Of the people who were involved in a court case in the preceding years, 15% of people surveyed reported paying a bribe to a judge. That's not just the people who reported a bribe happening in their case. That's the people who openly admitted, under anonymity of course, that they themselves paid the bribe. This percentage sounds relatively tame until you realize that state courts alone open about 102 million cases every year, according to the U.S. Bureau of Justice Statistics. Which means that this percentage comes out to approximately, drum roll please, 15,360,000 2,000 judicial bribes each year. 15 million! If this figure is accurate, that means that judicial bribery would be occurring at a rate of 42,082 times per day, or 29.22 times per minute, just barely over 2 seconds in between bribes. But wait, I hear you say, 100 million cases a year? That's impossible! Actually, no. It's not impossible if you think about it. Most of us have at least been to traffic court at least once in our lives. Think about how many people there were there to enter a plea. There's gotta be around 300 people there. Most of them will simply plead guilty, pay their fine, and be done with it, but that still counts as a case being opened. Now multiply that figure by 52 weeks per year, and multiply that by the 3,134 counties in the USA. That comes out to 48,890,400 traffic court cases opened every year. And that's not even considering counties that have more than one traffic judge, or courts that accept pleas on multiple days of the week. So just on traffic court alone, we've gotten darn close to half the figures specified by the Bureau of Justice Statistics. So yes, I can absolutely believe that there are 100 million court cases opened every year. However, Transparency International provides the highest estimate of judicial bribery. How do the other sources fare? Well, Seeker.com has the middle-of-the-line estimate. Their figure comes out to 2.5 million judicial bribes. This is certainly less than the 15 million mentioned above. However, according to the FBI, only about 1,197,704 violent crimes were committed across the entire nation in the year of 2015, the most recent year for which statistics are available. Now don't get me wrong, that's still 1,197,704 more than it should be, but that means that the number of annual judicial bribes, if Seeker's figure was accurate, would trump the number of violent crimes committed across the entire nation more than twice over. Yale Law Journal has the most generous estimate, coming in at bullying. Judges in local, state, and federal courts across the country routinely hide their connections to litigants and their lawyers. These links can be social. They may have been in law school classmates or share common friends. They might be in-laws. Occasionally, they are literally in bed together. While it's unavoidable that such relationships will occur, when they do create a perception of bias, a judge is duty-bound to, at the very least, disclose that information, and if it creates an actual bias, allow a different judge to take over. All too often, however, the conflicted jurist says nothing and proceeds to rule in favor of the connected party, while the loser goes off without realizing an undisclosed bias doomed her case. Oh, what does that woman know, I hear you thinking? Maybe she's just butthurt about losing a high-stakes case. Okay, well, how about an actual judge saying that the system is corrupt to the bone? That's right, we've got one of those. John F. Malloy was a retired Arizona judge who died in 2008, but not before publishing, in 2004, a book that shed an incredible amount of light on the judicial system. Malloy began practicing law in 1946 and served as a judge from 1957 to 1969, slowly climbing the chain of command until he reached the position of Chief Justice of the Arizona Court of Appeals. I think it's safe to assume that this guy, A, knows what he's talking about, and B, is testifying against his interests, since he was in the best position to profit from the bribery and corruption mentioned earlier. Malloy writes in his book, "The once honorable profession of law now functions fully as a bottom-line business, driven by greed and the pursuit of power and wealth, even shaping the laws of the United States outside the elected Congress and state legislatures." Pay close attention to the first line in that quote. Notice how he says it fully functions as a bottom-line business. In other words, truth and justice play 0% role in the legal system today. Profit is 100% of the system. So just what exactly can you reasonably expect to happen if you find yourself in a case with a corrupt judge? Remember that I pledged at the beginning of this video to only use specific incidents in order to illustrate the problem that I've already pointed out. To that extent, here are some examples of judicial corruption manifested as arbitrary rulings that ruin people's lives. In 1971, a teenage girl named Linda McFarland was sterilized without her knowledge by having her tubes tied up. Linda thought she was getting her appendix removed. The sterilization was ordered by a judge after her mother, Ora, asked the judge to order it. No evidence was presented. No witnesses were called. Linda herself was never even notified of the proceedings. She only learned what happened 2 years later, after she got married. The judge had forever deprived her of the ability to have a family for no other reason than her mother asked him to. In 1975, a man named Flor Lopez had moved back into an apartment he had previously moved out of. It just so happened that the landlord, one William Vanderwater by name, was also the local judge. How exactly did Lopez get back in the apartment? We don't know, because his right to his day in court was taken from him. Because after he was arrested, Judge Vanderwater forged a document for a plea of guilty, fabricated Lopez's signature on it, and then proceeded to sentence Lopez to a term of imprisonment. Lopez was never appointed any counsel, and he was never even given 2 seconds to tell his side of the story. In 1977, a Florida mother named Diana Dykes had her son Aaron taken from her for no other reason than Another judge just wanted to care for Aaron instead. The Florida Department of Health and Rehabilitative Services refused to give the medical recommendation that Aaron actually needed to be removed from the home. But that didn't stop the judge, named A.J. Hoseman, from signing the order anyway. Dykes was never told about the hearing to have her parental rights terminated. She never knew anything was going on until the cops came to take Aaron away. At this point, some of you are probably thinking, Jesus, can't you come up with any incidents that occurred after I was born? Well, yes, I can come up with a few. How about one that happened just a couple years ago? Please remember that these are only illustrative incidents, so of course they're going to be few and far between. I've already given three sources showing that these numbers of bribes are literally in the millions every year. So, there's that. As recently as 2015, Michigan Judge Lisa Gorsiga threw some kids in juvenile detention, not because they actually committed a crime, but because they didn't want to meet their dad for lunch. Granted, I can understand why some people would want families to stay together and bond. But remember rule of thumb number 2. The fact is, the bottom line is, the kids did not commit any crimes. If you want to make it a crime to not be with your dad, you can petition the state legislature to ask them to make it a crime. But it wasn't a crime in Michigan at the time to refuse to meet your dad for lunch. Judge Gorsiga, however, decided that it was her place to usurp the legislature and impose her arbitrary views of right and wrong on these kids, rather than simply applying the law. So she ordered the kids to meet her dad. When they refused, they were thrown in prison, despite being minors. As I said a moment ago, there are literally thousands of examples besides these, but I will stop here because I think you get the point. So what can we usually expect when a judge is corrupt? From these examples, we can usually expect the judge to not even give you an opportunity to tell your side of the story, and issue life-destroying rulings that you have no say in, or any way to get an appeal on. You don't have to have done anything wrong, you just have to have gotten on the bad side of whoever happens to be in power at the moment, and they'll make up stuff to charge you with. If the judge can't do it legally, then he'll do it illegally. He'll ignore the facts, ignore the law, ignore the truth, ignore justice. But here's the biggest atrocity of it all when it comes to judicial corruption. I might be inclined to accept all of this corruption begrudgingly as an inescapable part of living in an imperfect world, if the rest of the government actually did something about it, or at least tried to. But you know what usually happens when a judge gets caught breaking the law from the bench? Nothing. Absolutely nothing. The most well-known means of keeping judges from becoming totalitarian is impeachment. This is this part of the system of checks and balances that we're taught in school. But I don't think I even so much as need a source to tell you that this is an ineffective remedy. In the same social studies classes where we're taught about the system of checks and balances, we're also taught that it is extremely rare for a judge to be removed from office via the impeachment process. So if you're planning on writing your representative to demand an impeachment, don't hold your breath. Most states, as well as the federal government, have set up judicial conduct organizations, or JCOs for short. These usually have various names, ranging from the Judicial Discipline and Disability Commission to the Judicial Accountability Office, and everything in between. However, for simplicity's sake, we will refer to these organizations generically as JCOs. These JCOs are supposed to be the government's answer to judicial corruption. They are essentially the judges of the judges, and have the authority to investigate judicial misconduct and punish judges when they are found guilty. Even better, unlike the legislatures responsible for impeachment, these guys don't do anything at their day jobs except investigate and punish judicial corruption. So they don't have to balance their schedules. Sounds perfect, doesn't it? Often, however, these JCOs are just as corrupt as the judges they are supposed to keep in line. After all, if Walmart is going to bribe a judge to rule in their favor in a class action lawsuit filed by some of their former employees, what makes you think they aren't going to bribe the JCO to exonerate the judge for taking the bribe so that more judges will be willing to accept their bribes in the future? Okay, maybe I'm being a little harsh on these guys. After all, most states, as well as the federal government, explicitly restrict the JCO's powers by law. The JCOs are often expressly forbidden from interfering in judicial actions that directly relate to the merits of a decision or procedural ruling. In layman's terms, the mere fact that the judge applied the law incorrectly or decided the case wrong is not normally enough for the JCO to be allowed to punish the judge. To the untrained eye, this seems like a legitimate and fair rule. JCOs are usually ill-equipped to decide if a judge applied the law incorrectly. Usually the Court of Appeals are the ones you want to go to for that. JCOs are only supposed to step in for cases of bona fide corruption. There's a difference between making a mistake and being corrupt, so it makes sense, right? But here's the real problem. Courts of appeals have no power to punish the corrupt judges, only reverse their decisions. So while the JCOs do not have the power to reverse decisions, they are the ones usually vested with the power to punish judges for making the decisions in the first place. Let me give you an example that you can probably relate to. Imagine if one of your kids walks through the kitchen while you're cooking, gets a devilish look on his face, and knocks over a glass of milk entirely on purpose. Now further imagine that all you did was clean up the spill. You don't even force the kid to clean it up. You clean it up for him. You don't spank him. You don't ground him. You don't take away his toys or video games. Nothing. You just clean it up and then say to yourself, there, the situation has been taken care of. Well, that's basically the Court of Appeals' relationship to the trial courts without the JCOs to supplement their functions. Now fast forward 20 years. Imagine what kind of person your kid would grow up to be if that's the way you consistently handled parenting. Well, that's basically what the judicial system here in the USA has grown into. For that matter, sometimes the erroneous application of law is still evidence that the judge is corrupt. Remember rule of thumb number 4? It applies here too. Since most acts of corruption usually occur in secret, oftentimes the nonsensical ruling is the only evidence the aggrieved party has of the corruption. Now, if the JCOs investigated the complaint and confirmed, only after hearing all the relevant evidence, that the erroneous ruling was based purely on an erroneous but still good faith belief that the judge was following the law, then so be it. But there's a difference between reaching that conclusion after a thorough investigation and using that as an excuse not to launch an investigation at all. All too often, however, the latter is exactly what happens. Meanwhile, judicial scholar Gerald Stern opines, although improper influence, bias, and corruption have always been recognized as grounds to remove a judge from office, they are not the sole grounds for discipline. When a judge's acts are so obviously contrary to the law, it might not matter why the judge acted as he or she did. But even if you could argue that the JCOs have their hands tied when the only evidence of corruption is the illegal rulings, do you know what other aspect of the JCOs is just as perplexing and doesn't have that excuse?
In the already rare event that the JCOs do indeed act to enforce the law against the judges, they will almost never hand out a punishment that has any consequences.
It is important to note that when I say consequences, I don't just mean that it shakes the judicial system and sends a powerful message to other judges not to be corrupt. That would be ideal, but when I say consequences, I mean the judges don't even so much as suffer a $1 fine. In the already rare event when complaints do result in sanctions, these sanctions usually amount to nothing of actual consequence. Just a reprimand or censure, which are both basically just the same thing. A letter saying shame on you, but no action. As the LA Times writes, the vast majority of complaints against judges result in no discipline, and most misconduct is resolved by sending judges private letters. Even the California JCO itself, called the Commission on Judicial Performance, admits that it is extremely rare for them to do anything that actually punishes the judge in any meaningful capacity. They admit on their website that from 1995 to the present, a span of more than 20 years, there have been only 11 removals done pursuant to complaints filed with them. I use California because it has the largest population of any state, therefore there are the most data points I can use. But maybe California is just a corrupt state. Well, I certainly can't show you the statistics for every state. I mean, if I did, this video would be 3 times as long as it already is. So, just to show you that it isn't a fluke, let's do a 180. Let's go from the liberal haven of the USA to the conservative haven and second largest state in the nation, the state of Texas. Honestly, they seem to be even worse. I was able to find records of 55 suspensions from 2002 to the present, but I was unable to find evidence of even one single solitary case where a judge was removed from the bench permanently. So the million-dollar question is, why? When there is so much evidence of corruption, why is it so rare for judges to be brought to justice? I'll let that question stir as we discuss the next few sections. Section 1-2, Prosecutor Corruption. You thought judges were the biggest factor in the justice system? Think again. Prosecutors play almost as essential a role in the criminal justice system as judges do. Indeed, Clarence Walker of the Drug War Chronicle writes, prosecutors are arguably the most powerful figures in the American criminal justice system. Let's get something out of the way right off the bat. The United States has more people sitting in prison at any one time than any other nation in the world. This is not a per capita prison population. It's not a measure of the percentage of the total population sitting in prison. It's a measure of how many people are in prison right now as a flat number. Furthermore, the United States' prison population is not the largest in the world by a slight margin. It's the largest in the world by a landslide. According to the World Prison Brief, as of the time of this writing, the USA had 2,145,100 people in prison. The second place country is the communist and totalitarian capital of the modern world, China. Well, at least China's in the top 5, as they should be. But do you know how many people they have incarcerated as of the World's Prison Brief's most recent, as of the time of this writing, report? Only 1,649,804 people. So the USA has a prison population more than 30% bigger than the supposed totalitarian capital of the world, despite the fact that China has a much bigger population to potentially breed criminals. Now, why would I begin this section with this statistic? Because I want to ask you, why do you think this is so? Is it because the USA just has more criminals than any other nation? I highly doubt that's the reason. I mean, most of us still react with shock and disgust when we hear about somebody committing a heinous act. So it's not like our culture is one that breeds criminals or teaches people that crime is okay. When a large number of otherwise good people routinely get thrown in prison, chances are it's the system that's in need of rehab, not the people. I brought up this statistic first in order to lay the groundwork for my thesis for this section. The criminal justice system is just as corrupt as the judicial system. Just to clarify, there is a difference between the judicial system and the criminal justice system. Just like how there's a difference between the police departments who arrest suspected criminals and the prisons those guys go to live out their sentences. Cases in the criminal justice system are usually supervised by a judge after the charges are filed. This is part of the system of checks and balances we are taught in school. The judges are supposed to be checking and balancing the criminal justice system, which is part of the executive branch of government, not the judicial branch. However, there is much more to the criminal justice system than just the courts. Most of the corruption exposed by this section will be dealing with acts committed before the defendants are even called into court to enter a plea of not guilty. Before we examine how deep the corruption runs among prosecutors, we must first understand just what exactly is a prosecutor and what are their functions. Obviously, they decide who to charge with what crime. That much is common knowledge. But their specific day-to-day job functions are a bit more varied. Prosecutors do more than just try to get the defendants convicted as consistently as possible. As a collaborative effort from the American Bar Association in April 2008 writes, among lawyers, a prosecutor is in a unique position. Normally, a lawyer is free to, indeed expected to, zealously advocate on behalf of his or her client. Prosecutors, however, are not simply advocates for the government. They are also ministers of justice whose aim is not to win a case, but that justice shall be done. As such, it is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. At least in theory, that is supposed to be the prosecutor's role. So, what exactly are prosecutors expected to do to fulfill that function? After all, simply asking the prosecutors to avoid improper methods to produce a wrongful conviction, that's pretty vague and open to interpretation, isn't it? Generally speaking, prosecutors have a handful of rules of thumb to follow. They must disclose to the defense counsel all evidence in their possession that has any tendency to exonerate the defendant. To do otherwise is called a Brady violation, so named because it was first created by the U.S. Supreme Court case of Brady versus State of Maryland. Lawyers typically name case laws after cases that created them. Perhaps the most famous example of this, outside of law enforcement circles, is the Miranda rights, e.g. the part where cops have to tell you your rights when they arrest you, named after the case of Miranda versus the State of Arizona. In addition to that, they must not use or attempt to use any evidence they know is inadmissible. While they can argue the law to the jury, they have to do so accurately. They must not use testimony they know to be perjured. And if they are to offer a witness amnesty in exchange for their testimony, they must disclose that amnesty arrangement to the defense. After all, just like with the exonerating evidence, the prosecution has to disclose all evidence that could possibly help the defendant's case, including discrediting the prosecution's witness by showing they have a conflict of interests. They also must disclose anything else that might potentially help the defense, including but not limited to previous lies told by the witness earlier in the case before those lies were corrected, and any criminal record the prosecution's witnesses have. A good chunk of these rules of thumb are no-brainers to most of us. Don't submit false evidence or perjure testimony? Who with two functioning brain cells would think that's okay? Well, apparently a lot of prosecutors seem to think that's okay. These highly educated, graduate degree carrying lawyers entrusted with the most powerful spots in the criminal justice system, they apparently think that's okay. Because every year, an estimated 10,000 people are wrongfully convicted, according to Ohio State University. And this study goes out of its way to make clear that they were going for conservative estimates, so the actual figure is probably even greater. Meanwhile, Peter Joy from Washington University School of Law in St. Louis, Missouri, has cited studies showing that as many as 43% of wrongful convictions were caused, at least in part, by prosecutor misconduct. Put those two statistics together, and that means that each year, approximately 4,300 people, aka an average of approximately 11.78 people every day, are convicted of crimes they didn't commit because the prosecutors, being the highly educated bunch that they are, thought it was okay to break the law themselves. Actually, I don't think they thought it was okay. I just don't think they cared. For the record, that only includes cases that were overturned on appeal. That does not even count the number of cases where the high courts decide not to even look at any new evidence that has surfaced, either because the case was plea bargained and therefore the defendant signed away his right to appeal the conviction, or because they just didn't want to review it. So, precisely what kind of tactics do prosecutors routinely use? Well, at this time, I will provide my illustrative specific incidents. Please understand that these are only meant to illustrate the statistics I've already provided, namely the part about prosecutor corruption being a factor in over 4,000 wrongful convictions each year. First, Peter Joy from Washington University, yep, him again, writes they have prosecuted black men hiding evidence the real killers were white. They have prosecuted a wife hiding evidence her husband committed suicide. They have prosecuted parents hiding evidence their daughter was killed by wild dogs. John Thompson of New Orleans, Louisiana, was exonerated in 2003 of first-degree murder for which he was originally sentenced to die. It was revealed that the prosecutors had evidence they had never disclosed to the defense that the real killers had a completely different blood type than Thompson. In 2013, in the state of Arkansas, Timothy Howard, who had spent 14 years on death row, had his murder conviction overturned when it was revealed that the crime lab who analyzed the DNA evidence and purportedly linked it to Howard had recorded in its report that at least 4 mistakes were made in analyzing the DNA. Although they were able to obtain new DNA from Howard to do a retest, the DNA from the crime scene was irreparably damaged. Prosecutor Tom Cooper actually took that note out of the crime lab's report and handed everything else in the report to the defense, except for that one note. Just with these examples, are you starting to see a pattern here? These are not simply prosecutors who lazily don't disclose evidence because they forgot to. In many cases, especially cases of death row inmates, the prosecutors are going out of their way to manipulate the evidence to suit their own needs. And the people have the unmitigated gall to ask why killers can sit on death row for 15 years before finally being executed. This is why. This right here. Now, in some cases, you might argue in their defense that they didn't know the evidence was exonerating. Like, for example, in the case of Timothy Howard, maybe the prosecutor just didn't think about the possibility of the crime scene DNA being irreparably damaged. I mean, Howard could still have been guilty anyway, right? He was the prime suspect even before the DNA was sent to the crime lab. Well, to answer that, I say this. First of all, this guy is supposed to have gone to law school and obtained a graduate degree in order to know these types of things. Isn't it his job to know these things? But even still, there's another problem. If he didn't think the evidence was exonerating, why hide the evidence at all? What harm would disclosing the evidence do if it wasn't exonerating? It's not like that one page would have substantially increased the cost of mailing the report to the defense attorney. The prosecutor had to go out of his way to remove that page from the report. Why not just make a photocopy of the entire report and then submit a verbatim copy of that entire report to the defense with no alterations whatsoever? That certainly would have been quicker and easier than removing just one page and submitting everything else. So by going out of his way to hide that evidence, he obviously felt there was some strategic advantage to hiding it. So if he wants to argue that he didn't think it counted as exonerating, shouldn't he hold the burden of proof on that? Since the odds he didn't think that are 1,000,000 to 1? So the question is, why? Why do prosecutors shirk their duties? Some web pages, who I will not provide links to since they do not provide any evidence to support their claims, and I'm not making any statements without evidence to back it up, speculate that it might be because prosecutors are trained to believe the defendant is guilty, so it is often hard to hand over evidence that could be useful to this criminal getting away with his crimes because they want to see this criminal get brought to justice, not manipulate the legal system to get off on a technicality. If that were the case, you could argue, at least theoretically, that prosecutors' hearts are in the right place, even if their logic is screwed up due to a broken system of prosecutor training. However, 2 things. First of all, remember rule of thumb number 1. You don't get to commit a Brady violation just because you think it's the quote-unquote right thing to do in this case. Second, that excuse is lost in the first instance for cases where the evidence the prosecutor suppresses cannot be interpreted in any other way than proving the defendant's innocence. Of the examples I presented earlier, the best example of that is the case of John Thompson. As you can see from that example, the evidence the prosecutor withheld in that case was the fact that the blood type did not match Thompson's. This is not a matter of the prosecutor believing the defendant is guilty, even though there might be some reasonable doubt as to his guilt. This is the matter of the prosecutor having irrefutable evidence that the defendant is innocent and deciding to charge him anyway, just because. In other words, the prosecutors don't care about catching bad guys. They only care about wins and losses, W's and L's, and anything at all, including killing innocent people, is worth getting a W. Forget having no shame. Do these people even have souls? Do these people even count as human? Remember earlier when I said that corruption is worse than murder, and I also argued that corruption begets murder. I wasn't kidding. So, even if some prosecutors, as the various web pages speculate, simply trust their instincts more than the evidence, that cannot be used as a sweeping explanation as to justify why prosecutors commit these Brady violations. However, like with the judicial corruption, I might not be quite as pissed off about any of this if the law were enforced against these corrupt prosecutors with any degree of consistency. But they aren't. The Center for Prosecutor Integrity, in its 16-page publication titled An Epidemic of Prosecutor Misconduct, says it best. I couldn't say it better if I tried, so I'll just quote verbatim what the passage says right here. So what happens when ethical codes are violated? 9 studies have analyzed the professional consequences of prosecutor misconduct. Collectively, these studies examined prosecutorial misconduct conducted at both the state and national levels from 1963 to 2013. Of the 3,625 instances of misconduct identified, these studies reveal that public sanctions are imposed in only 63 cases, less than 2% of the time. Often, these sanctions represented only a proverbial slap of the wrist. The most common sanction was to assess the prosecutor with the cost of the disciplinary hearings. In only 14 instances was a prosecutor suspended or disbarred from practice. Let me repeat that, just in case it didn't sink in the first time. Over the course of 50 years, that's 50 years, or half a century, with an average of 72.5 cases per year of confirmed corruption, prosecutors were suspended or disbarred exactly 14 times. Less than 0.4% of the total number of cases of corruption. Even judges get suspended or removed more often than that. Last chapter, I managed to identify a total of 66 suspensions and removals from 2 states alone, over a span of 21 years, not 50. Just to clarify, when this report says 3,625 cases, that doesn't mean the number of complaints that were filed in that time period. Because I guarantee you, more than that many are going to be filed across the entire nation over 50 years. I'd be surprised if there were that many complaints filed in 1 year in one state. No, when this paper says 3,625 cases, They specifically state that it is cases of misconduct identified. In other words, in more than 3,500 cases over the past half-century, the disciplinary bodies have simply stated, yeah, you committed a crime. You should be punished, but we're not gonna punish you, just because. But they are not the only ones who have done studies on this thing. The Huffington Post has documented numerous studies by various impartial organizations about prosecutorial accountability. In 2003, the Center for Public Integrity looked at more than 11,000 cases involving misconduct since 1970. Among those, the center found a little over 2,012 instances in which an appeals court found the misconduct to be material to the conviction and overturned it. Less than 50 cases resulted in any professional sanction for the prosecutor. In 2010, USA Today published a 6-month investigation of 201 cases involving misconduct by federal prosecutors. Of those, only one prosecutor was barred even temporarily from practicing law for misconduct. The Justice Department wouldn't even tell the paper which case it was, citing concern for the prosecutor's privacy. A 2006 review in the Yale Law Journal concluded that a prosecutor's violation of the obligation to disclose favorable evidence accounts for more miscarriages of justice than any other type of malpractice, but is rarely sanctioned by courts and almost never by disciplinary bodies. An Innocence Project study of 75 DNA exonerations, that is, cases where a defendant was later found to be unquestionably innocent, found that prosecutorial misconduct factored into just under half of those wrongful convictions. According to a spokesman for the organization, none of the prosecutors in those cases faced any serious professional sanction. A 2009 study by the Northern California Innocence Project found 707 cases in which appeals courts had found prosecutor misconduct in the state between 1997 and 2009. But of the 4,741 attorneys the state bar disciplined over that period, just 10 were prosecutors. The study also found 67 prosecutors whom appeal courts had cited for multiple infractions. Only 6 were ever disciplined. Remember John Thompson, the guy whose prosecutor hid the non-matching blood type from him until a couple of weeks before his scheduled execution? Well, he did an interview in 2013 for Huffington Post, where he, once again, put it more succinctly than I ever could. This isn't about bad men, though they were most assuredly bad men. It's about a system that is void of integrity. Mistakes can happen, but if you don't do anything to stop them from happening again, you can't keep calling them mistakes. I know what you're thinking, but what about the courts themselves? Can't the judges who are overseeing the court proceedings in real time fine the prosecutors or hold them in contempt of court? After all, didn't you state at the beginning of this section that this is what the system of checks and balances is all about? I did say that. Judges indeed can issue punishments to prosecutors, as well as other attorneys who break the rules in front of them. But they won't. In December 2013, at the time Chief Justice of the United States Court of Appeals, Alex Kozinski, stated in a court opinion, there is an epidemic of Brady violations abroad in the land. Only judges can put a stop to it. This was actually the dissenting opinion. In other words, the majority of judges seem to think that it's perfectly okay to ignore blatant violations of the law in the cases they are overseeing. Or, again, as I stated before, I don't think they think it's okay. I just don't think they care. Section 1-3, Police Corruption. Recently, police brutality has come slightly under media scrutiny, the key word being slightly. It's enough for people to start protesting in the streets. The most notable of these protests is the 2014 civil unrest in Ferguson, Missouri. But even still, the true scope of this corruption is sorely underrepresented. Let's start off with some hard statistics, shall we? That's why you're watching this video in the first place, right? In 2016 alone, the most recent year for which full statistics are available, there were a total of 1,092 confirmed instances of people murdered by cops in the line of duty, according to The Counted, a continuously updated online database of police murders owned and maintained by The Guardian. This comes out to an average of about 2.99 deaths every single day. Of these 1,096 murders, 169 of them, aka 3¼ murders per week, were of unarmed victims. According to Mint Press, cops are attempting to counter these accusations by stating that they have to defend themselves against a war on cops. To that I say, what are you talking about? What war on cops? There is a website called the Officer Down Memorial Page, who tracks how many officers die in the line of duty each year. For 2016, the same time period that there were 1,092 police shootings of civilians, it states that there were 145 police deaths. However, the number of cop murders of unarmed people alone still exceeds that. But a quick look at the causes of death caused the discrepancy to be even more glaring. Not all 145 cop deaths were from criminals resisting arrest. Of the 145 cop deaths in 2016, 4 were classified as accidents, 1 died of some sort of duty-related illness, 4 more died of a 9/11 related illness, whatever that means, a whopping 10 died simply of a heart attack, 1 guy died from a fall, 2 drowned, a whopping 21 guys died from car crashes, 10 were struck by vehicles or trains, but no indication that the driver was trying to hit him, and 8 died from a motorcycle crash. Taking those out of the grand totals, we are left with only 84 cops in 2016 who were killed on purpose by criminal assailants. The number of police shootings of unarmed civilians alone more than doubles that amount. So if there is a war on cops, it definitely looks like they're the ones picking the fight. Remember when I said that corruption begets murder? Well, here it is rearing its ugly head again. But even if you take police murders out of the equation, and why would you damn sociopath, you've still got a huge problem dealing with cops if you're Hispanic, and an even bigger problem if you're black. Yeah, I know, I promised to keep obvious stuff out, but few people know the true breadth of the problem. In fact, racial profiling is so rampant across the nation that it's practically legally sanctioned. Would you like to take a guess where I'm pulling this next statistic from? Go ahead, guess. The Guardian? No. The LA Times? No. The New York Times? No. The Huffington Post? No. Peter Joy? No. This time it's the United States Department of Justice itself. Viewing a 2005 report from the Bureau of Justice Statistics, it is revealed that if you're black and you get pulled over, you're 2.9 times as likely to be searched than if you're white, and 3.26 times more likely to be searched if you're Hispanic rather than white. If you come into contact with police at all, traffic stop or otherwise, you're twice as likely to have force used against you if you're Hispanic than white, and 3 times as likely if you're black. Even the Harvard Law School instructors realize that this is a problem. As Charles Ogletree, a black professor at Harvard Law School, summed it up, "If I'm dressed in a knit cap and hooded jacket, I'm probable cause." But here's the really big shocker. At least it would be a shocker if you've been watching the video up to this point. This time around, industry leaders are actually making strides to do something about all this corruption. Oh, pinch me! Could it really be true?
Hallelujah! 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 Hallelujah!
In 2011, the FBI did a study on police corruption. At the beginning of this study, they report, over the past few decades, great strides have occurred in the law enforcement profession. To begin with, many police agencies have avoided hiring candidates who have low ethical standards and have identified those onboard employees early in their careers who might compromise the department's integrity. In addition, research has discovered new methods of testing candidates for their psychological propensity to act ethically. However, unethical conduct by the nation's police officers continues to occur in departments large and small. Wait a minute. What was that last bit? Unethical conduct continues to occur in departments of all sizes? Well, it certainly seems like corruption is a lot like software and music piracy. Despite the industry's best efforts, they haven't been able to even slow corruption down, let alone stop it. So what gives? Well, reading further into this FBI report sheds some light on this issue. Officers receive training and a large quantity of rules and regulations and are entrusted to perform their normal day-to-day duties within those guidelines. Supervisors generally are not involved unless a complaint against an officer or a serious incident requires their response. So while it is incumbent upon the leaders to create an atmosphere that promotes ethical conduct, it falls to each member of the organization to ensure that this standard of integrity is carried out. Oh, so the problem is that police chiefs just don't monitor their officers' conduct unless somebody actually speaks up about it? If a cop shoots another person, the chief isn't even going to review the use of force report unless somebody witnessed the murder and complains about it? Yeah, scratch what I said earlier. They aren't doing very much about police corruption. Rather, once a cop gets hired, it seems that the chiefs of the various departments seem to feel like bypassing those steps is proof that the cops are incorruptible. The chiefs then seem content just sitting around munching on donuts and just looking important until the news media exposes it. So just what happens when cops are actually caught engaging in misconduct? Well, unlike with judges and prosecutors, it is actually very hard to come by nationwide statistics. Not because there aren't any organizations dedicated to monitoring police corruption, because Lord knows there are plenty of those, but because there is no national reporting requirement. In fact, many places have laws to purposefully keep the details of misconduct investigations out of the public eye. So maybe we should start believing that our police departments are purposefully turning a blind eye to complaints of misconduct until they prove otherwise by publishing their results. But police corruption goes far deeper than just use of force. Often, the most atrocious acts are committed after a suspect is arrested. Police-induced false confessions are among the leading causes of wrongful convictions, writes Amelia Fritz, Michael Blue, and Sarah Tomeszko in a joint essay for Cornell University Law School. Granted, confessions are not supposed to be admissible if they were coerced by police. However, the problem there is that coercion is defined by the law, not that it matters anyway, because, as we've discussed in this video already, judges and prosecutors don't give a rat's butt about the law. But anyway, it is defined as inflicting or threatening to inflict some type of illegal injury. The key word being illegal. If they say that you'll be sent to prison for life if you don't confess, that doesn't count as coercion, because it's totally legal for them to inflict that injury on a convicted criminal. More importantly, for the police acts to be legally classified as torture, the police have to actually beat the crap out of you. As in, they have to physically hurt you. It is perfectly legal for them to hold you for hours, even days, at a time in a room designed for complete sensory deprivation, with no contact with the outside world, no sleep, and no comforts of any kind until you just can't take it anymore. Confessions done just to make that stop are still perfectly admissible. Even better, the cops can even lie to you to get you to confess. You didn't kill that person? Well, they found the murder weapon with ballistic markings matching the bullet that killed the victim in your gun safe. How do you explain that? I mean, they didn't find the gun with the matching ballistic markings, they just pulled that out of their butts because you spent 30 consecutive hours without confessing. But you can't prove that, sitting in that white room with no way of seeing what they have on file. This whole system of interrogation, from the white walls designed to psychologically wear you down, to the part about making up phony evidence, is official police department policy in most places. This isn't just some cops going against protocol to get a confession because they firmly believe you're guilty even though they have no evidence except their gut. This is literally how police are trained to behave. They are literally taught by their mentors and instructors to have these kinds of God complexes. This system of psychologically wearing down people is very, very effective at getting people to confess to crimes they didn't commit. Saul Casson, psychology professor at the John Jay College of Criminal Justice and Williams College, opines, "The reason why people confess to crimes they did not commit is because they are subject to pressures of interrogation, a highly aggressive form of social influence. In the interrogation, especially in American-style interrogation, people can become so stressed and so broken down that they start to feel so hopeless about their current situation that they can come to believe in a rational way a confession is in their best interests. In some cases, they get so confused by the fact that American police are permitted to lie about evidence, and I mean lie about DNA, prints, surveillance footage, polygraph results, that in some cases people accused of crimes, particularly kids and others who are limited intellectually, become so confused by the lies that they actually come to believe that they have committed this crime they did not commit. They wonder why it is they can't recall it. They are led to believe that it is possible for people to transgress without awareness, for people to do something terrible and repress it. So they develop basically an inference that they must have committed this crime. Of course, if you think about it, police interrogations make no sense even if you take away the God complexes where police assume their gut over the objective evidence. Think about it. In what circumstance would the police have so much evidence of a suspect's guilt that they know beyond any reasonable doubt that any statement to the contrary is a lie, and yet at the same time have such flimsy evidence of the suspect's guilt that they still need a confession to convict you? How can the evidence they have going into the interrogation be both solid and flimsy at the same time? I can only think of one hypothetical situation where that would be the case. A cop might find himself in that situation without suffering from a god complex if the evidence he has that proves the suspect's guilt was illegally acquired and therefore can't be used in court. However, if that is the case, it's still the government's fault it even came to that in the first place. But sometimes it goes beyond believing that the suspect is guilty, even if you have no evidence aside from your gut. Sometimes it's a matter of knowing full well that the suspect is innocent and going out of your way to make up evidence against him. It is at this point I will begin my section requisite list of illustrative specific incidents. In 2010, a Seattle cop arrested 2 black men at gunpoint. These guys did not even match the description for the robbers that the anonymous caller gave. Instead, they were arrested on site for
being black in Seattle,
according to their attorney. But perhaps the most appalling part of this arrest was not that they were arrested for no reason, but when they were sitting in jail, jail security cameras could hear the cop tell them,
"Oh, you're going to jail for robbery. That's awesome.
Robbery.
I'm going to make stuff up.
Robbery.
Here
Yeah,
on.
I'm gonna make things.
listen again.
I'm going to make stuff up."
they filed a complaint with SPD's so-called accountability office, but the cop was exonerated. In an interview with a local Seattle TV station, Police Sergeant Sean Whitcomb states that,
I can tell you we take them seriously, but people have to believe that. They have to trust the system. They have to trust the process.
this guy openly admits he shouldn't have to show any evidence that the system is not corrupt. The system works because they say it does. He isn't even pretending like there's anything more to it than that. Or how about this? A man named Nick Yaris was arrested in 1982 when a cop who pulled him over decided to manhandle him to the pavement. In an article Nick Yaris wrote many decades later for Crack.com, he explains, "I stopped at that point, yelling okay, and he put me in the car. He then sat in the car and calmly composed himself before calling dispatch and telling them he was now under attack, that there were shots fired and he needed assistance because he was still under attack. And then he looked in the mirror at me with a smirk, like, now you're gonna get it." Yaris was eventually sentenced to death because of this made-up charge and spent 21 years on death row before he was exonerated by DNA evidence. Or how about this incident? Brett Darrow of St. Louis, Missouri was harassed by police not once, not twice, but 3 times. The second and third times were probably done in retaliation to the first time he was harassed, because the first time he published an audio recording of the altercation on YouTube, where the cop, apparently upset that he wasn't being shown the respect he felt he deserved, went on a profanity-laced tirade, complete with threats of making up evidence, and with such colorful language as,
You wanna try me? You wanna try me tonight? You think you have a bad night? I will ruin your night. You wanna go to jail for some reason I come up with? Ever get smart mouth with a cop again, I show you what a cop does. Try and talk back. Talk back to me again. And I bet I can say you resisted arrest or something. You wanna come up with something? I come up with 9 things. When we come up with some more? When you turned in, you failed to use your turn signal, the right turn signal. You wanna try me some more? Huh? Come on, smart. Give me an attitude a little bit more. I bet you I can guarantee I close this car by the time I'm done.
See, these police are not simply making heat-of-the-moment judgment calls on people they think are guilty and then find themselves unwilling to admit they were wrong, so they try to force confessions to retroactively justify their actions. No, these guys know full well that what they are doing is blatantly illegal and are making the conscious choice to do it anyway out of pure malice. Okay, you're probably thinking right now, all we need to do is make cops carry cameras everywhere. Then they can't hide anything. Oh, but there is a way to hide their corruption. Remember those St. Louis cops who have been harassing Brett Darrow? Well, St. Louis already requires its cops to carry dashboard cameras in their squad cars. These cameras would have picked up the cop threatening to make up resisting arrest charges against Brett Darrow. So why was the department reduced to using Darrow's footage of the altercation? The answer is because they lost the footage. The chief just couldn't find it.
And now the patrol car video is missing. The chief can't find it.
So if Darrow did not already have the camera of his own, it would have just been his word against the cops. And you can probably guess how often the chiefs choose to believe the word of civilians over their own officers. Of course, we can put two and two together. You and me, we're not idiots. We know that the department intentionally deleted the footage. In fact, in the case of the Seattle cops saying, "Yeah, I'm gonna make stuff up," the news media was, at the time, investigating an epidemic of cop footage mysteriously disappearing.
It's the latest shocker uncovered by a Como4 problem solver investigation into the SPD's vanishing videos.
That particular clip was probably just inadvertently overlooked in their deleting efforts. But how do we prove they did this on purpose? Section 1-4. The corruption of the prison system. I admittedly saved this section for after discussing the other three sections. After all, some of us probably support the dehumanizing nature of prison systems. After all, they're just criminals. Punishing them is what prison is supposed to be all about. However, I hope that the last three sections have shown you that just because someone is convicted doesn't mean they were rightly convicted. Quick question. If you went to prison on some bogus charge that a cop made up, or because the prosecutor withheld exculpatory evidence, or because the judge was bribed into convicting you, what is the thing you should be scared of the most? Getting beaten and raped by other inmates? Well, you'd be shocked. The majority of the brutality in prison comes not from inmates, but from the guards themselves. At Lowell Correctional Institute, the largest women's prison in the USA, it was reported in December 2015 by the Miami Herald that the prison guards had been beating, raping, and molesting the women at said prison, depriving them of basic necessities like soap and toilet paper, and to force them to flash their breasts on a whim. The male guards would waltz in on the women's showers and watch them shower. Many guards would enter the cells in the middle of the night and drag the women to isolated areas to rape them. Think this is one isolated prison? Think again. Vogel Law, an attorney law firm servicing the states of New York and New Jersey, explains that misconduct and excessive force against inmates still occur today throughout the country. They then explain that the two most common forms of abuse on inmates are violent assault and sexual assault. But you know what the most infuriating thing is? It's not that the authorities know about the corruption and don't do anything to stop it. More on that in a little bit. No, the most infuriating part about all this prison violence is that these prison guards, more than any other group of government officers we've discussed up to this point, have a reason to be so violent, and they don't take it. This excuse wouldn't be a legal defense to their actions, see rule of thumb number 1 for details, but it might morally justify their conduct in the eyes of a lot of voters. Specifically, the fact that prison is already a violent environment. Despite popular misconception, you're actually less likely to be murdered in prison than on the streets, according to Slate magazine. But there are other forms of brutality besides homicide. Documentary after documentary repeatedly describes prison as being a place of constant struggle for control. The inmates these guards are supposed to be keeping under control always manage to inflict pain, either on other inmates or on the guards themselves. As Slate magazine writes, someone living there, in prison, is less likely to be murdered than they would be elsewhere in America. That, however, is where the good news ends. The bad news, of which there is plenty, is that the life he faces is so brutal that he is more likely to commit suicide than if he were free, and his chances of being raped and beaten, possibly repeatedly, appear exponentially greater. I bring that up to say this. There are loads of people out there who advocate for just killing a lot of the violent criminals and being done with it rather than paying to house them in prison where they can continue to hurt people. Prison guards could actually use violence against violent inmates in order to put those inmates in their place and show them who's boss. They could get their daily fill of sadistic violence on these inmates and actually be somewhat justified in the eyes of a great number of people. These people have a golden opportunity to be violent practically gift-wrapped for them, and they go out of their way to only use violence and sexual assault for the most detestable of purposes. Granted, this would not morally justify the violence to some people, myself included. Some goody two-shoes might argue that it's asinine to teach inmates to be non-violent by being violent to them. I am one of those people, but those goody two-shoes would be missing the point. The point is not that the prison guards shouldn't use violence against violent inmates. Remember, this video is dedicated to exposing corruption, and specifically corruption, in all levels of government. The problem, as far as this video is concerned, is that the prison guards do use violence, except that they do it for all the wrong reasons. Sure, not using violence at all would probably be ideal, but using violence against violent inmates would still be better than using violence exclusively for personal amusement. If you're going to inflict violence on inmates, you should at least do it to those inmates who come closest to deserving it. Heck, using violence for both personal amusement and to keep the inmates in their place would still be better, less evil than what they are currently doing. The wardens know about this corruption, and unlike the JCOs and Attorney Conduct Offices, or ACOs for short, we've discussed in previous sections, the wardens actually admit that the corruption is rampant. Ashley Fans, writing for CNN in 2015, explains, when Gary Hayward went through training to become a prison guard, his instructor warned him that there would be temptations behind those walls. He said, "Look to your left. Now look to your right. One of you is going to smuggle something in. Some inmate is going to talk you into doing bad." I honestly don't know what's worse. Turning a blind eye to evidence of corruption so you can maintain plausible deniability? Or knowing and admitting that corruption is rampant and still doing nothing to stop it? Honestly, which one is worse? Tell me what you think in the comments. I'm curious. Which one is worse? So why is the system so corrupt? Eric Fox, writing for Business Insider, speculates that it might be due to the low pay and low opportunities for advancement. He writes that prison guards, quote, make significantly less money than police officers and generally have significantly less training. New York State correction officers have 8 weeks of formal training, while state police in New York have an intensive 26-week course. Many go into corrections as a last resort. But for me personally, that just doesn't make any sense. First of all, as we've discussed, police, judges, and prosecutors are just as corrupt as prison guards. Judges and prosecutors have nearly a decade of training, and as we've discussed at length in this video so far, their corruption is perhaps even worse than those of prison guards. So the lack of training cannot possibly be to blame. Nor can the low pay be to blame. If that were the case, then how come we don't hear story after story of fast food employees trying to embezzle money from the cash registers or safes? So, just what exactly gives? Well, criminal justice professor Chris Minton gave an interview to Eric Fuchs for Business Insider. He acknowledged that a lot of prison guards, including him, took that job because they couldn't get a job anywhere else in government. In other words, these people wanted to be cops or federal agents, but did not get the job for one reason or another. Considering all the corruption I've exposed in the previous sections, my personal guess is that the majority of these corrupt prison guards were already looking for a position they could abuse to their advantage anyway. My guess is that their levels of corruption were already past the point of no return. But that's just my personal theory. Don't quote me on that. But you know what isn't theory? What is actually hard fact? What happens when the inmates can't take it anymore and file a lawsuit? If you guessed the judges rule against the inmate for no other reason than being corrupt, as you've discussed in the first section, then you would actually be dead wrong. At least in this circumstance, there already exists a get-out-of-liability-free card for the prisons that is actually in the books. It's called the Policy Custom Rule. The rule goes like this. A prison or jail cannot be held liable for the acts of their guards unless these acts were done pursuant to an official institutionalized policy or custom. So all the warden has to do is turn a blind eye to blatant violence from the guards, and presto changeo, the prison's hands are clean. Think I'm exaggerating about this? Well, to show you that I'm not exaggerating, I will begin my section requisite list of illustrative specific incidents. In January 2009, in Omaha, Nebraska, a man named David Johnson was arrested in the middle of the night and taken to the county jail. David had a prescription of Dilantin for a seizure disorder. Repeatedly on his first night in jail, he asked to be administered his medicine before he had a seizure. The jail guards repeatedly told him that pill call was scheduled at 9 a.m. for all inmates, regardless of their individual medical needs. He was further warned that he would be punished if he continued to ask for his medicine. When he was sitting in court, waiting to give his plea, he suffered a grand mal seizure. When he sued the jail simply flashed a written copy of their policy, basically a piece of paper and nothing more, that said that they must provide comprehensive medical care to all inmates based on individual need. This completely contradicted what the guards told Johnson about the 9 a.m. pill call, and yet that was all it took for the jail to be absolved of any liability for Johnson's seizure. In Marshall County, Mississippi, a woman named Princess Anderson actually died from a beating suffered in a county jail. Partially at fault was the hospital who, perhaps because they were bribed into doing so, discharged Princess without treating her. When her mother, Angela Anderson, sued for wrongful death, the United States Court of Appeals held the city and hospital harmless for Princess's death on the grounds that holding Marshall County liable for Princess's death requires an official policy. It is worth noting that Princess was pregnant at the time, meaning that she not only lost her life, but the life of her unborn child as well. Corruption begets murder. In January 2008, in Clayton County, Georgia, a 67-year-old man named Bruce Goodman was viciously beaten by his cellmate while incarcerated at the Clayton County Jail. The jail guards turned a blind eye to his beating, but the jail was nevertheless exonerated because the jail did not have an official policy or custom of ignoring inmate violence. Still think I'm exaggerating about this whole policy custom rule? Remember that these specific incidents are meant to be illustrative, not exclusive. There are literally thousands of cases on the books where prisons were absolved of liability for the most heinous of acts simply because they had a sheet of paper that seemingly contradicted what their actions were. But there's even more legislation on the books protecting corrupt prisons from being held accountable. Specifically, I'm talking about a piece of legislation called the Prison Litigation Reform Act. Congress passed this law in 1996 because they felt that there were too many prison guards being held accountable. Well, they didn't put it like that. Officially, they said there was a swarm of prison lawsuits that were clogging up the court system. However, instead of doing something about the prison systems across the nation that sparked this new wave of lawsuits in the first place, they decided to just limit inmates' access to the courts. How did they do that, you ask? Well, here's a brief rundown of all the provisions the PLRA has. Inmates cannot bring their claims to the court unless all intra-departmental remedies have been exhausted. So the prison can simply have an obscure step in the grievance process that inmates don't even know about, and yet, if they don't magically know about it and use that step, they have not exhausted the intra-departmental remedies, and therefore the lawsuits will be barred. You cannot recover any damages, e.g. money, from the prison or any of their guards unless you've suffered a physical injury or sexual contact. You might think, at first glance, that this seems fair, but what if the inmates suffer severe emotional trauma due to the constant harassment, threats, and badgering? How come free people can recover money damages for that kind of conduct, but inmates can't? Basically, think about the stats I gave at the beginning of this section, where inmates in the nation's largest women's prison, they were being denied basic hygiene tools and were demanded to flash their breasts on a whim. That doesn't count as sexual contact, the key word being contact, and yet it's still an atrocity. Shouldn't they be allowed to recover money damages against the prison? There are other provisions in the Prison Litigation Reform Act, but I would have to practically give you a crash course on being a lawyer for you to understand most of them. By this point, however, I think you get the idea. So does the Prison Litigation Reform Act offer a balance? Does Congress place any sort of requirements or duties on the prisons themselves? Like, for example, does it require prisons to keep security camera footage for any length of time to give the inmates enough time to pull the footage during a case, so the prisons can't just delete the footage to cover up evidence of their abuses? Does it do anything of the sort to protect inmates? Ha! Of course not! Why should Congress lift a finger to hold government agencies accountable? These two laws, the Policy Custom Rule and the Prison Litigation Reform Act, really paint a picture of corruption in this country that I will expand upon in the next two sections. The enforcement bodies are indeed turning a blind eye to corruption, despite irrefutable evidence. But it's not simply because they are too lazy to get off their butts and do their jobs. Rather, they are going out of their way and actively fighting to protect this corruption and maintain this status quo. Section 1-5. those who know of the corruption are intimidated into silence. I know what most of you are thinking. If the corruption really is as bad as you say it is, why hasn't somebody spoken out about this corruption before now? It takes unanimous participation of everyone involved in a scheme to keep it secret, but it only takes one whistleblower to expose it. Well, for starters, there have been plenty of people who try to expose the corruption. After all, the past 4 sections up to this point have been chock full with source after source, each trying to expose the corruption. At this point, I don't think it's a matter of people not trying to expose the system. I think it's just a matter of whether you noticed. Second, most, though not all, of these sources usually have one thing in common. They are somewhat detached from the system. They may have credentials, like the various law schools who understand the system, but most of them are still on the outside looking in. So, some of you might reasonably wonder, why don't other attorneys or judges besides the retired John Malloy write about this corruption? The answer is, there are indeed a ton of industry insiders out there who are disgusted with the legal system and would be delighted to see it reformed. But the problem is that if they try to speak out against the system, they face serious consequences. MC Maui writes for a news website called dailychaos.com. They don't speak up. The reason is you get targeted and you could lose your license, said Barbara Kaufman of lawyers who witnessed judicial misconduct. The pattern of losing their careers or facing hefty fines after speaking out against judges has legal experts worried. Think this is limited to only one state? Think again. Carol Reiger from the University of Minnesota, after discussing a particularly egregious instance where the United States Court of Appeals for the 8th Circuit suspended an attorney who criticized a judge, explains that although the 8th Circuit's decision is one of the most egregious, it is by no means an isolated incident. Many other courts have imposed disciplinary sanctions for lawyers' statements about judges. Most states' codes of attorney conduct have provisions that state attorneys must not insult a judge or accuse him of any wrongdoing, absent an objectively reasonable factual basis. There's a major problem with that, but we'll get into that in a minute. For now, I'd like to focus on a slightly less obvious problem. Why are the judges the only ones protected by this provision? I can certainly understand the rationale behind not wanting anyone, lawyers or otherwise, to make accusations against anyone without an objectively reasonable factual basis. But why are judges the only ones who get this protection? Why not the bailiffs, or the clerks, or the court reporters, or even better, the opposing parties who the attorneys have the most incentive to make up stuff about? In fact, regarding that last one, attorneys are actually expressly permitted to make up accusations about those people. It's called the litigation privilege. If you're suing somebody, e.g. a cop who threatened to make up charges against you, the defense attorney can make up whatever accusations he wants to make you look like a monster to the jury, and it's perfectly legal. It doesn't count as perjury because the attorney was never sworn in as a witness, and it doesn't count as defamation either because the litigation privilege expressly permits the attorney to publish defamatory material. So no, only judges are protected against baseless accusations. Why is that? The answer is because the judges wrote these codes of attorney conduct themselves. That's a minor problem. However, I promised you a major problem. That problem is that, in 99% of cases, the attorneys do indeed have objectively reasonable factual bases for their claims, but the committees decided to disbar them anyway because they just don't care. To prove that, I think this is as good a time as any to whip out my illustrative specific incidents. In 2009, Florida attorney Sean Conway criticized a Fort Lauderdale judge on his online blog. The problem is that his criticisms, according to Jolie Hilden, writing for FindLaw.com, were coupled with some recent substantive points. Conway opined that the judge at issue provided far too little time, one lone week, for trial preparation in criminal cases. He added that she thus forced lawyers to convince their clients to waive their Florida speedy trial rights in order to gain more preparation time, meaning that those rights, in effect, weren't treated as rights at all, but rather as privileges to be revoked at will. Despite having the objectively reasonable factual basis that the Code of Attorney Conduct requires, Conway was still fined $1,200 and warned that further criticism would result in his law license being revoked. But perhaps the most atrocious example is the case of Richard Fine from California. What makes this example so atrocious is that A, he is actually suffering incarceration because of his justified criticism of judges, and B, even when the news media exposed this scandal, the government still tried to justify their treatment of him. Specifically, Fine objected to the way Los Angeles County openly paid judges extra money in addition to the money the judges were already being paid by the state government. He considered this to effectively be open bribery of the judges, creating a conflict of interest whenever the judges were presiding over the cases where the county was a party. Therefore, he feels the judges should have recused themselves, which makes perfect sense. The state, however, was not content simply taking away his law license. Fine actually spent about 18 months in the Los Angeles County Jail for criticizing the judges for being corrupt. County Jail spokesman Steve Whitman admits that he was probably done more time in that jail than a lot of drug dealers, and that his cell could be put to better use housing violent offenders.
So this is unusual?
The length of time, I would say absolutely, yes. We now have 4,500 in this, just the men's central jail, most of which are felonies, most of which are violent offenders.
But you have someone like Richard Fine, who is a non-violent offender.
Absolutely.
Who is sharing space.
Absolutely.
With all of these felons.
Could we use that cell? Absolutely.
But perhaps the most disgusting thing about this whole ordeal isn't the incarceration. When CNN finally got around to uncovering the story, the prosecutor had this to say.
What he ultimately did was to delay proceedings, to level false accusations against judges. All of those lawsuits were found to have been frivolous and meritless.
Wow! So what we have here is the prosecutor, by his own admission, taking away Fine's livelihood and imprisoning him for 1.5 years for no other reason than the very judges who were accused of corruption said that those accusations were frivolous. He offers no evidence whatsoever that the accusations were false, other than the interested judge's uncorroborated word. And he isn't even pretending like there's anything more to the government's motives than that. Can these people get any more shameless if they sat down and tried? Now, I know what you're thinking. Isn't this code of conduct a violation of attorneys' free speech rights? Isn't it unconstitutional for that reason? Well, I would certainly agree with you on that. The problem here is getting judges to acknowledge it. And you can probably guess how effective that usually is. In fact, you probably can't guess it. You're probably overestimating how effective it is. In fact, whenever it is raised by attorneys who face disbarment, the judges usually ignore the argument entirely. Based entirely on their published decisions, an industry outsider would probably be none the wiser that the free speech claim was even raised by the defendant in the first place. In the rare event tribunals will acknowledge and address the free speech argument, they usually say that this provision of the Code of Attorney Conduct is not unconstitutional because attorneys sign away their constitutional rights as a condition of being allowed to practice law for a living. They sign away their rights when they decide to work for the government. Remember that point. It's going to become hella crucial later on. But for now, the problem is that this only applies to attorneys. Ever since 1967, the Supreme Court has held that every other government officer, from cops to bureaucrats to school teachers and everyone in between, except attorneys, cannot legally be fired for speaking their mind against the government. The only people who are given this special treatment in this regard are those who are best equipped to expose rampant corruption. And that's not coincidence. In addition to the whole waiving free speech rights argument, they also argue that this provision of the Code of Attorney Ethics is necessary to promote public confidence in the judicial system. Why, yes, if attorneys are permitted to expose rampant judicial corruption, then that would indeed tarnish people's beliefs that the judicial system is honorable and efficient. So once again, we have government officials not even pretending like their motives are even slightly uncorrupt. By their own admission, they are trying to create a cult of personality to make the people think they are perfect, whether that belief is true or not. I've seen this before. Where, oh where, have I seen this before? Oh yeah, in George Orwell's dystopian novel, 1984. I'm sure you've heard the phrase, Big Brother is watching you, right? Well, that phrase comes from that book. Anyway, here's the passage that the real-world judiciary's attitude reminds me of. Whatever the party holds to be the truth is truth. Do you remember, he went on, writing in your diary, freedom is the freedom to say that 2 + 2 make 4. Yes, said Winston. O'Brien held up his left hand, its back towards Winston with the thumb hidden and the 4 fingers extended. How many fingers am I holding up, Winston? 4. And if the party says that it is not 4 but 5, then how many? 4. The word ended in a gasp of pain. The needle in the dial had shot up to 55. The sweat had sprung all over Winston's body. The air tore into his lungs and issued again in deep groans, which even by clenching his teeth he could not stop. O'Brien watched him, the 4 fingers still extended. He drew back the lever. This time the pain was only slightly eased. How many fingers, Winston? 5, 5, 5! No, Winston, that is no use. You are lying. You still think there are 4. How many fingers, please? Although this hopefully gets your blood boiling, I hope it also shows you that there's a potential light at the end of the tunnel. They want the people to think the judiciary is honorable and efficient, and they'll silence anyone who tries to offer evidence to the contrary. Does that tell you anything? It should show you that they know that the biggest threat to their current state of power is the people. The people could overthrow this corrupt establishment in the blink of an eye if enough of us hit upon the idea to reform it. Keywords being enough of us. Remember that, as it will become very important in Title 3 of this video. But for now, how about getting you even angrier with even more evidence of corruption? You know that enforcement agencies turn a blind eye to the corruption of judges and prosecutors, right? What you probably didn't know is that it's the same people who discipline prosecutors who also discipline other attorneys. Now, why is that important? Well, think about the way judges are reviewed. We have the Court of Appeals, and then we have the JCOs. Those are two completely separate entities, staffed by two completely separate teams of people. This may not fully justify their contradictory decisions, for reasons I've just stated in the first section of this video, but at least they can each individually maintain plausible deniability, arguing that their decisions are their own and are not influenced, one way or another, by the decisions of the other agency that reviews judges. But with the Attorney Conduct Offices, or ACOs for short, that excuse is lost. It is literally the exact same groups of people who decide not to punish prosecutors despite irrefutable evidence of corruption, except in 14 cases over the past half-century, while turning around 1 hour later and finding, suspending, or disbarring private attorneys who attempt to call the system out on its corruption. It's like I said at the end of the last section. These people are not simply turning a blind eye to corruption despite irrefutable evidence, simply because they are too lazy to get off their butts and do their jobs. Rather, they know full well what they're doing, and they're actively fighting to protect this corruption. Oh, but it gets even worse, if that's possible. With attorneys, the judicial system at least has created some semblance of an excuse for itself, however weak it might be, by saying that attorneys waive their free speech rights when they apply to be lawyers. But even if they don't have that excuse, they'll still engage in retaliation, including violent retaliation, without even trying to make even the slightest semblance of justification for their actions. They will go after you.
Section 1-6. Protest corruption? Go to jail. You don't have a law license, so they can't take that license away. Most of us don't have to worry about losing our livelihoods. So why haven't there been massive street protests against all this corruption if the evidence is so overwhelming? By this point, you've probably realized that these people have absolutely zero shame. The law is whatever they say it is. Therefore, if they decide you're a criminal, then you're a criminal, even if they have to make something up to charge you with. They will, and often have, used that as a means of curbing ordinary citizens' freedom of speech and bypassing news reporters' rights to freedom of the press. This is a lot harder to trace than the corresponding retaliation against attorneys, since they rarely, though not never, publicly acknowledge their true motives. However, there is still some evidence of this happening. I'm going to have to break one of my rules for this section. I promise to keep specific incidents to a maximum of 4 per section, and only to help illustrate the points. The problem here is that there is no national database by either the government or by any third-party government monitoring organizations, so there are no actual statistics that I can cite. However, by this point, I hope you've learned that government corruption is as widespread as Earth's atmosphere. At this point, I hope you can accept that these incidents are not isolated incidents, since you've already seen enough evidence that you can believe this happens often as well. These are merely the incidents where the government officers actually admitted to their true motives. The times when government officers act with pretext is probably 1,000 times greater. With that said, let's move on to the cases where the government openly persecuted people who protested them. Bob Unruh from WND has the first major story. On July 1st, 2015, Florida Judge Mark Mahon issued an order for the police to arrest anyone engaging in demonstrations or disseminations of materials that degrade or call into question the integrity of the court or any of its judges, e.g. claiming the court personnel or judges are corrupt, biased, dishonest, partial, or prejudiced. He states the penalty for violating this order could include confinement, a monetary fine, or otherwise. They don't even have to outright accuse the courts of corruption. All these protesters have to do is call into question the corruption of the courts, and they get arrested for it. Granted, the judge did say that peaceful protests would still be allowed. Problem here is that he makes no effort whatsoever to define what counted as peaceful. He expressly states that any protests that call the judicial system corrupt were covered by that order, so he obviously does not count that as peaceful. How is that not peaceful? While we're on the topic of Mark Mahon, at the time he issued that order, he was getting ready for a trial against Michael Hoffman, who was arrested for holding up an anti-TSA sign near the Jacksonville airport. Officially, his charge was trespass, but the problem there is that he was standing on a public sidewalk. However, another judge, one Brent Shore by name, forbade Huffman from offering any evidence that he was on a public sidewalk. Basically, he was accused of trespassing on private property and was not allowed to offer evidence that he wasn't on private property. These people are not even trying to cover up how corrupt they are. Amy Goodman of Democracy Now! Gives us our next story. On April 11, 2016, 400 protesters from 104 different organizations marched up to the White House to protest, but not riot, the corporate influence on political lobbying. They were all arrested. This was not even the first time they were arrested for protesting. Leader Kai Newkirk explains that he, along with over 400 other protesters, were arrested in 2014 after protesting the Supreme Court decision of McCutcheon v. FEC, a sister case to Citizens United v. FEC. Newkirk protested that, and he was arrested for it. On October 23, 2015, some people protested outside the Rikers Island jail in the Bronx, demanding that the prison be shut down because of ongoing abuse of inmates and other corruption. For full details, see section 1-4 of this video. At least a dozen people were arrested outside the entrance, according to News 12, the Bronx's local news station. What's most shocking about this is that they say there's at least a dozen. As in, they don't have an exact number. Why not? Doesn't the city keep a record of all the people they arrest? Or are they just trying to cover up some of these arrests? Mark Thompson, the publisher of a city newspaper called The Fan and Focus, attempted for years to obtain copies of court documents that were supposed to be public record. Thompson and his attorney Russell Stuckey were both arrested on July 1st, 2016 and charged with making a false statement in an open records request. Bear in mind that it is not a crime to make false statements unless you've been sworn by a tribunal to tell the truth. So the judge and prosecutor are literally just making stuff up to prosecute Mark with. Furthermore, even if that is a crime in their state, do they have any evidence that these statements are false? Pfft, of course not. Justin Gardner of the Free Thought Project further explains that the vindictive judge made it plain to see that her aggression is based on nothing more than emotion. I don't react well when my honesty is questioned, Weaver said. It's clear that this is a personal vendetta against me. I don't know how else to explain that. So, just what exactly was Thompson trying to get? What scandals was he trying to expose with these public records? Well, in 2015, he observed the bailiff making numerous racial slurs during a trial. He was not allowed to bring a video camera or audio recording device into the courtroom with him, because courts are funny that way. So, to obtain evidence to use in his news report, he asked the court stenographer for an audio recording of the trial. The stenographer refused, saying that the racial slurs were off the record. So Thompson proceeded to write the story anyway. In it, he pointed out how the stenographer had omitted the racial slurs from the transcript. The stenographer then sued Thompson for libel. Apparently the transcript was accurate because she says it was. In 1952, a pastor who alleged that a judge's decision in a, at the time, recent case was influenced by political alignment was held in contempt of court and fined $100, nearly $1,000 in today's money, despite doing this entirely on his own time, in his own church, with no government officers nearby. In 2013, Daniel Brewington, who lost his child custody rights in a divorce case, decided to go online and rant. He was sentenced to 2 years in the county jail for his outburst. His charge? Perjury! Even though he was in his own home and wasn't even sworn in. On July 15, 2016, 18 people were arrested for protesting the way police would shoot black people on sight, according to Edward Murphy of the Portland Press-Herald. Officially, the reason for their arrest was that they were blocking a public street and obstructing traffic. The problem is that the police themselves actually shut down the streets to allow the protesters to protest. The police initially allowed the protesters to have their protests, and then retroactively changed their minds and decided to arrest the protest leaders. But all of that is nothing compared to the case of Sonny Shoe. Nothing even comes close to the case of Sonny Shoe. Everything else, that's just gravy compared to the case of Sonny Shoe. Shoe was the victim of foreclosure fraud. He was enjoying lunch one day in the Queens, New York home he owned fee simple. Some people just came waltzing in. They were potential buyers, expecting the house to be empty. Turns out, some local bank had driven by Shoe's home, decided, I'd like to make some money selling that house, and then cooked up a power of attorney and fabricated Sonny Shoe's signature onto it. Despite the signature being forged, the Queen's judge simply proceeded to eat the bank's word up with a spoon. Sonny Shoe was evicted from his home, and he never got a say in the matter. Well, Sonny did not take this sitting down. He tried to raise a media scandal out of this matter. So what happened when Sonny tried to expose this corruption? Was he fined a lot of money? Was he thrown in prison for weeks or years at a time? No. He was murdered.
A fatal blow to the head 3 days after he uncovered evidence that the judge was committing tax evasion by not reporting some of the most valuable extra homes he was supposed to be paying tax on, such as a $1 million beach home. Officially, the death was declared an accident. Now I know what some of you are thinking. Just because he made an enemy out of a local judge and ended up dead a little while later doesn't necessarily mean that those two things were in any way connected. That might be true, but you know what does connect them? A YouTube video that Sonny Shu uploaded just a few days before his death, where he explained that the judge issued him a death threat, so we would know who his killers would be if he were dead.
Hi, my name is Sonny Shu. For the security concern, I make this recording. And if anything wrong goes to me, it should be come from Judge Gloria and his people, because before I have been kidnapped by his people, by his and threatened and intimidated by his people, not file a complaint against Judge Gloria. So I make this recording for the safety, for the protection. If anything wrong, please go to the Judge Gloria and his people.
Oh my God. I'm sorry if these examples seem few and far between. As I said at the beginning of this section, it's usually extremely rare for government officers to be so upfront about the reasons they are retaliating against their critics. However, these few cases are all it really takes to open the floodgates. It's called precedent. For example, Daniel Brewington's incarceration was upheld on appeal and is now published precedent under the citation Brewington versus State. Because it is published, that means it is now binding precedent, also known as case law. In other words, there is no longer just some rogue judge breaking the law and not getting punished for it. Judges all across the state of Indiana now officially have been given the green light to go after and imprison anyone who dares to criticize them. So even though these examples are quantitatively small, one instance is all it takes under the right conditions to open the floodgates to hundreds or even thousands of similar cases. Be afraid. Be very afraid. Section 1-7. The Little Things. These past 6 sections have discussed some of the most atrocious and widespread abuses perpetrated by our government. But these abuses alone could not survive if they were acting entirely on their own. Judges ordering the arrest of anyone who criticizes them? That wouldn't last very long if the cops were arresting the corrupt judge instead of the people. So before finishing up Title I, let's take a look at all the little things, the little screws and cogs that hold this massive corruption machine together, that aren't big enough to justify their own section, but still deserve mention. Number 1, lying. I can hear you right now. This video is supposed to be about things that aren't already common knowledge. Yes, that is true. However, it is specifically because everyone takes government lying for granted that nobody ever bothers to analyze it in depth, and therefore nobody really fully realizes its true implications. First of all, how can you tell when something is a lie? This is important because it begs the question, how often are we deceived as a result of these lies? But at the same time, we are often left with no choice but to trust the word of various government officers.
For example, suppose you're serving on a jury. The defendant is being charged with possession of cocaine. As evidence, the prosecution's star witness, Officer Johnson, testifies that he searched the premises and found a Ziploc bag full of about 5 pounds of cocaine hidden under the defendant's couch cushion. To support this claim, he not only brings in the bag of cocaine itself, but also shows a photograph that he took at the scene showing the bag of cocaine sitting on a cushionless couch seat. Well, how do we know that's actually what happened the night the defendant was arrested and not something like this? The defendant didn't show the cop the respect he felt he deserved. The cop, in anger, pulled off the couch cushion to reveal nothing whatsoever. The cop took a 5-pound Ziploc bag of cocaine and placed it on the couch seat where the cushion used to be. He then snapped the photo. Then, at trial, he completely lies and claims that he found the defendant in possession of cocaine. Now, as a juror, what do you do? Do you assume that he is lying simply because he could be lying? If you acquit the defendant simply because of the possibility that the cop is lying, do you risk allowing a criminal to get away with his crimes scot-free? So, as you can see, we, the citizens, are often placed in a difficult spot, where we are often forced to believe a government officer, even though they lie all the time about the stupidest of things, simply because the thought of not believing them is even scarier. Of course, a lot of people think the majority of lies can be uncovered by forcing government officers to record everything they do on video camera. That would be 1,000 times harder to fake than mere photographic evidence, right? But that leads us to the next little thing that government does to cover up their corruption. Number 2. Destroying or suppressing evidence. An idea rapidly gaining popularity in the USA in recent years, one that I've mentioned in this video several times already, is to make cops carry around video cameras, so they catch everything that happens. If they try to make something up or arrest somebody because they aren't being very respectful, the cameras would pick that up. But what do you do if the cop deletes the footage so you can't use it against him? Think that's not a very common problem? Well, as of the time of this writing, I did a search on YouTube for videos of cops deleting footage. Bear in mind, I did this search in a private window, so my personal search history couldn't tamper with the search results. The results I got were simply astronomical. 77,900 search results. And that's just the cases where A, the victim managed to get it on video despite the cops' attempts to delete the footage, and B, the video was uploaded to just this one site. But here's the problem. We only know about these 77,000 incidents because somebody managed to catch them on video despite the cops' attempts to destroy the evidence. We have no real reliable way of telling how often this happens because, well, that's the whole point of destroying the evidence. It goes beyond simply deleting video footage. Nearly any evidence the cops don't want to exist will be destroyed. For example, in 1997, in Kansas City, Missouri, a man named Theodore White Jr. was arrested because his ex-wife, Tina, accused him of molesting their daughter. Their daughter kept a diary, which reportedly contained her opinions that Teddy was a great dad who never mistreated her at all. However, a cop named Richard McKinley, who, for the record, was actually Tina's new boyfriend almost immediately after she separated from Teddy, literally took that diary and burned it to ashes. The main problem when evidence goes missing is, how do you prove that the cops did it? More importantly, how do you prove they did it on purpose? It's actually actually rare for a cop to slip up and either fail to destroy evidence or leave some evidence behind that the original evidence was destroyed, like with McKinley and the burning diary. To succeed on such an accusation, you have to prove that the cops A. destroyed the evidence, B. on purpose, and C. with the express intention of depriving the citizen of exonerating evidence and or evidence to incriminate the cop. Number 3. Summary dispositions. This is one of the easiest methods of covering up corruption, since it is laziness in and of itself. Most other methods, especially the two I've discussed in this section up to this point, usually require some sort of active effort on the corrupt officer's part. This, however, requires virtually no effort. For those of you who aren't part of law enforcement social circles, a summary disposition is when a judge issues an order or decision in a case without giving any explanation for his decision. So imagine if you managed to catch a cop on video saying he's going to make stuff up to arrest you on, and his attempts to destroy that video footage have failed for some reason. So you sue the cop. The cop bribes the judge to throw the case out, as just one of the literal millions of judicial bribes that will occur that year. The cop moves to dismiss that case, and the judge, as per the bribe, is going to grant that motion. How exactly does the judge go about fulfilling that agreement? Well, he could just make up some excuse. He could review the footage and say there was no evidence that the cop threatened to make up anything. But if he did that, people might catch on that there's corruption going on. So, to prevent that from happening, a common tactic employed by judges is to not give any reasoning at all. Instead, his order will simply say, the defendant's motion to dismiss is granted. The case is dismissed. And that's the end of it. Case closed. You lose. This is a fairly ingenious way of covering up corruption. You can't find any inconsistencies in the judge's logic when there is no logic. So how do you prove that this was done to cover up corruption? You can't read between the lines to find evidence of collusion when you just don't have anything to work with. This is actually an ingenious, in a comic book supervillain sort of way, method of covering up corruption. Not because of how subtle it is. If anything, it's even more blatant than trying to come up with some excuse. But because of how easy it is to do. It would honestly require more effort and work on the judge's part to come up with some half-baked explanation that is loaded with plot holes in it, than just to type a single paragraph to end it all. Sure, it's more blatant, but at the same time, the higher courts will give the trial judge the benefit of the doubt. It doesn't matter what the people think, and if they try to rally against the courts, they'll just be arrested anyway. Number 4. Jury rigging. Much like with lying, this is another no-brainer that nobody ever thinks about and therefore never realizes its full implications. For all intents and purposes, bribing the jury into issuing a verdict you prefer should be impossible. Juries are supposed to be selected at random. You have no way of knowing who you need to pay bribes to until the day of the trial, when it should be too late. However, there really is no reliable way of ensuring that they are indeed random. The clerk of the courts is usually the officer in most states responsible for summoning the registered voters to jury duty. They are not, however, required to use any particular method of summoning the jurors, so long as it technically counts as random. This effectively means that we are reduced to simply trusting the clerk's word that the registered voters were summoned to jury duty at random. Even if you might suspect that they weren't selected randomly, how do you prove that? You can't. Number 5. The harmless error rule. So, imagine if you found out that the prosecutor committed a constitutional violation during your case. Well, as it turns out,
that's only step one to getting your conviction overturned. The second step is proving that, but for this constitutional violation, the outcome of your case would have been different. In other words, the courts do not consider upholding the Constitution to be an end unto itself. The Constitution is just a means to an end. When it comes to trying to show that these people see the law as being malleable to whatever their whim is at the moment, I don't think you can get a clearer example than this. Now, in the government's defense, this law does have something remotely resembling a justification for it. Take, for example, a case in the state of Arkansas in 1995 against a defendant named Anthony Abernathy. He was charged with killing his girlfriend after he heard some rumor about her at a party. To help convict him, the prosecution brought up some of his past crimes. This is normally not allowed. It is generally considered prejudicial to bring up past transgressions since they don't prove that this one particular case happened, but instead tend to incite animosity from the jury, who will tend to throw the book at the man even if the evidence of the current crime is flimsy, just out of sheer spite. As the U.S. Judicial Advisory Committee put it best, character evidence is of slight probative value and may be very prejudicial. It tends to distract the trier of fact from the main question of what actually happened on that particular occasion. It subtly permits the trier of fact to reward the good man to punish the bad man because of their respective characters, despite what the evidence shows the case actually happened. And if you disagree with this rule of evidence, well, remember rule of thumb number 1. However, when the Arkansas Court of Appeals reviewed the case, they realized that even if you took Abernathy's criminal record out of the equation, the prosecution still had A. the testimony of Abernathy's friend saying that Abernathy left in a rage, B. the testimony of his neighbor saying that he heard Abernathy wailing on his girlfriend a few minutes after the friend said he left, and C. the taxi records showing that Abernathy left at exactly that time the friend stated and arrived back at his apartment at exactly the time the neighbor heard the beatdown. So, in the government's defense, do we really need to waste taxpayer money on another trial when it's clear the defendant was guilty even without bringing up his criminal record? However, the corruption comes not when the constitutional violation was clearly harmless, but when there is no direct evidence that it was harmful. Courts will affirm convictions in light of flagrant constitutional violations so long as it's possible the defendant would have been convicted anyway, writes New York Times while directly quoting a federal judge. Take, for instance, a Texas case of Calvin Burdine. He was convicted of capital murder and sentenced to death when his attorney literally slept through portions of the trial. Despite this gross violation of his right to counsel, the Texas Court of Appeals upheld the factual finding that the lawyer had slept, but overturned the grant of a new trial on the ground that Mr. Burdine had not met his burden of proving that the outcome of the case would have been different. What? Are you saying the impact this had on this case wasn't patently obvious? But this is more than a mere one-off case. In fact, it is well-settled precedent across the board. It doesn't matter what the constitutional right was, how it was violated, or how many times it was violated. You don't get the judgment reversed unless you can look inside a crystal ball and prove that your case would have been different. Number 6. Prosecutorial discretion. What if you don't sue the cop per se, but rather ask the prosecutor to charge him? After all, if you catch him on video, There's no way a jury could possibly acquit the cop, right? Well, unless the jury gets bribed, but it'll cost the cop a lot more to bribe 12 jurors than to bribe one judge. But what honestly makes you think they'll even get that far? What makes you think the cop will even be served with any indictment papers? Prosecutors can choose not to press charges against any person for literally any reason they want, no matter how corrupt. It's called prosecutorial discretion, also known as selective enforcement. In 1985, the U.S. Supreme Court explained why this nuance is on the books when they said, "In our criminal justice system, the government retains broad discretion as to whom to prosecute. This broad discretion rests largely on the recognition that the decision to prosecute is particularly ill-suited to judicial review. Such factors as the strength of the case, the prosecution's general deterrence value, the government's enforcement priorities, and the case's relationship to the government's overall enforcement plan are not readily susceptible to the kind of analysis the courts are competent to undertake." Granted, this law is not entirely without some arguable justification. In some cases, selective enforcement may be desirable. For example, a verbal warning to a teenager may effectively alter their behavior without resorting to legal punishment, and with the added benefit of reducing governmental legal costs. In other cases, selective enforcement may be inevitable. For example, it may be impractical for police officers to issue traffic tickets to every driver they observe exceeding the speed limit, so they may have no choice but to limit action to the most flagrant examples of reckless driving. The problem comes when prosecutors refuse to charge corrupt government officers, not due to a lack of evidence, but simply because they don't want to charge their law enforcement brethren. In a sick, twisted sort of way, I can almost see their point. After all, these people are often fellow soldiers in a war on crime. They have to build up a lot of trust with each other, since they can't do 99% of their jobs without each other's help. Something the Founding Fathers made sure of when they created the system of checks and balances. Even Jesus himself said, "Every kingdom divided against itself will be ruined, and every city or household divided against itself will not stand." Except sometimes they do. Once in a blue moon, and I mean an average of once per decade, a judge or cop might be charged with a crime. So it's not like they're afraid of having a sort of civil war between the agents of justice rather than working together. And that, right there, sums up the entire problem of corruption in a single concept, and it's a perfect main theme for Title I. There's no consistency when it comes to anything the government does. They never punish judges or prosecutors, except for when they do. They'll always believe a cop's word over a civilian's, except for when they don't. Prison guards will routinely use force and brutality against the inmates, except for when they don't. People have the right to freedom of speech and freedom of the press, except for when they don't. There's never any consistency when dealing with the government. Is it too much to ask for them to at least be consistent about what they do? That about does it for Title I. But before we move on to Title II, I know there are going to be people itching at the chance to post a comment and try to refute what I've said so far. So before you do, I want you to understand what sort of evidence you should provide. I am a reasonable man. I am willing to admit when I'm wrong. But it's going to take more than just some person saying I'm wrong to convince me that I'm wrong.
If you want to rebut my arguments and evidence, here are some guidelines to doing so. First, I don't want to hear complaints about trivial and purely technical errors I made in this video. For example, I already know of a mistake I made in section 1-3 of this video. When I discussed the average number of police killings of civilians per day last year, I divided that number by 365. However, 2016 was a leap year, so there were 366 days in that year, meaning that the number of daily police murders would have been ever so slightly smaller than the average I gave. You know why I didn't go back and redo that section? Because that doesn't detract from my main point. My main point for that section was the number of police killings of civilians is too damn high. And the cops' argument about there being a war on cops is completely unfounded. So if you're going to post a rebuttal comment, please try and rebut that point instead of focusing on trivial stuff. Maybe you could argue that it tarnishes my credibility, so you should automatically discredit everything I say because I lack credibility. However, it's not my credibility you need to be tarnishing. In this video up to this point, I've provided over 100 sources that I am entirely unrelated to back up my claims. And when this video is finished, I'll have provided over 140 sources. Try attacking the credibility of those sources instead. I also don't want to hear studies that show the actual number of corrupt acts committed is only slightly less than the figures I gave. Let's say you've got a source showing that the number of people in 2016 killed by police is, say, 963. Well, that's still too damn many. After all, I provided three sources showing how many judicial bribes occurred each year. Their figures were galaxies apart from each other, but even the lowest number was still too damn high. In addition, I don't want to hear about any disciplinary or accountability methods I might have neglected to mention. Is there some additional supervisory body for judges, prosecutors, or police I didn't mention? Well, that alone doesn't refute any of my claims. After all, as I've clearly shown over the course of this video, it's one thing for some method of enforcing the law to exist on the books, it's quite another for the government to actually use it. Last but not least, I don't want to hear about a particular case where a judge, cop, or prosecutor was actually punished for his corruption. Remember, I stated at the start of this video that I would focus on statistics, statutes, and case law to make my points. I said that I wouldn't dwell on specific incidents. I explained that the reason for that approach was that a single instance of corruption does not prove that the system as a whole is corrupt. Well, it also works the other way around. If you can show me one case where a government official actually got his comeuppance in the end, that is not evidence that the entire system is honorable, effective, and efficient. After all, I was able to find a study showing that 14 prosecutors were suspended or disbarred for their corruption. Does that count as 14 evidences that the system actually works? No, it doesn't, because those 14 cases were juxtaposed against a total of 3,625 cases of confirmed corruption, meaning that those 14
cases represented less than 0.4% of the grand picture. The same logic applies here. If you want to rebut my arguments, I want the same thing I've been presenting up to this point: statistics. Show me how the entire system not only has the accountability laws, but actually enforces those laws consistently. Consistently. Here are some examples of things I would accept as rebuttal evidence, provided that they came from reliable sources who have a sliver of credibility. Statistics showing that more than 50% of cases of confirmed corruption of judges and prosecutors result in suspension or disbarment. Third-party studies, keyword being third-party, showing that less than 1% of wrongful convictions are caused by prosecutor corruption. Studies from disinterested organizations, aka not tied to the government, showing that the number of judicial bribes each year is far less than 1 million. These guidelines are reasonable and are only what should be expected in the face of the sort of overwhelming evidence I've presented and will continue to present in this video. So, if you think you can rebut my arguments within these guidelines, then by all means, have at it. The comment section is open to you. Title 2. How did it get like this? We've covered extensively just how bad the current state of corruption is in the USA. The key word in that last sentence is current. What we haven't covered is the history. As the old saying goes, you can't know where you're going unless you know where you've been. So before we start thinking about a solution, perhaps it is best if we examined the history of how the government got so corrupt. Section 2-1. Sovereign immunity. So why is the system so difficult to reform? If a cop threatens to make up charges against you, couldn't you just sue them yourself? If the chief won't fire the cop and the prosecutor won't charge him, shouldn't you be able to seek justice in civil court? I doubt they would so flagrantly violate your rights if they knew they could be held liable for millions of dollars for it. Well, they've got another law on the books that makes it extremely difficult for you to do that. This time, however, the secret scam isn't something that's been developed over the course of the 20th and 21st centuries. No, this time the culprit dates back to medieval England. The law is called sovereign immunity, and it was brought to this country when our states, after becoming independent in 1776, adopted the English common law verbatim. To most people, this seems like a perfectly legitimate course of action. Common law governed the colony's day-to-day lives before we separated from Britain, and it seemed to serve us well. It was the best to just go ahead and say, we'll continue to use common law in one fell swoop, rather than painstakingly recreating the same laws that were developed over hundreds of years from scratch. But what most people, except lawyers, don't realize is that when we adopted common law into our legal system,
with no modifications whatsoever, we got sovereign immunity along with the package. So what exactly is sovereign immunity? Well, what it basically means is you can't sue the government. Even if they act illegally, even if they violate your most basic human rights out of pure malice, you can't sue them. Why? Because they're the government and they just get that special treatment because they say so. And right now you're probably thinking, wait a minute, the government is just above the law? That can't be right. I get they might cover up for crimes, but you're actually saying that they officially can't be held accountable even if they're caught? You've gotta be pulling my leg. I wish I could say that, but I'm not. In fact, that isn't even an unfortunate side effect of another law with slightly more honorable intentions. Case in point, like how that pesky Fourth Amendment can actually allow murderers to get away with their crimes scot-free because the evidence isn't admissible. The Fourth Amendment has honorable intentions, but sometimes these things just happen. Sovereign immunity, however, is not like that. Rather, the entire purpose of the doctrine of sovereign immunity is to allow government officials to not be held accountable. Think about it like this. Suppose you're a guest in somebody's house. Your host owns this house. He lights up a cigarette. You decide to light one up for yourself. He tells you not to smoke in his home. He's smoking in his own home, but he doesn't want you to smoke. It's a blatant double standard. Well, it's his house, right? So, I suppose that's fair. That is his right. That's one of the privileges of being a homeowner. Well, back in medieval England, the king basically took that logic and applied it to the entire country. It's his country. He owns that country. Therefore, he can do whatever he wants. Whatever he wants. The problem is that this doctrine applied to anything and everything. If the king ordered you killed, it didn't matter if you had done anything wrong. But wait, you say, what about the Magna Carta? Didn't that curb the king's absolute power? Well, yes it did, but only for nobles. Peasants like you and me were still subject to the king's whim, as well as the whim of his enforcers. The problem, as it applies in the 21st century USA, is that this goes against everything the USA is supposed to stand for. The Founding Fathers broke away from the British Empire specifically because they believed that the government's power was not absolute. Indeed, many political scholars agree with me. Aaron Chemerinsky, writing for Duke Law School, opines that sovereign immunity is an anachronistic relic and the entire doctrine should be eliminated from American law. The government itself admits that it is an arbitrary law that has no purpose for existing other than because they want it to exist. In the U.S. Supreme Court case of United States v. Lee, it explained that the principle has never been discussed or the reasons for it given, but it has always been treated as an established doctrine. So what we have here is the government, by its own admission, claiming that it is above the law, not because it is necessary for some greater good, but for no other reason than because F you. They aren't even pretending like there's anything more to it than that. I've seen this before. Again, this feels oddly familiar to the dystopian novel of 1984. Specifically, the following passage. The party seeks power entirely for its own sake. We are not interested in the good of others. We are interested solely in power, not wealth or luxury or long life or happiness. Only power. Pure power. The object of persecution is persecution. The object of torture is torture. The object of power is power. Now, is there even a single argument in favor of sovereign immunity that actually comes relatively close to justifying the law, even if it may not completely justify it? Yes, actually. Imagine if a cop decides to arrest a citizen on made-up charges. Suppose the city is sued for millions of dollars for that cop's actions. Is it fair to the citizens of that city that they have to spend the next few years with insufficient police protection, insufficient fire protection, insufficiently funded schools, under-maintained roads, and other city services being insufficiently funded, just because one cop decided to go rogue? If a private company goes bankrupt, most of us can survive long enough until a new company can enter. However, a city cannot go without police protection, not even for one day. That is the closest I, personally, have ever seen anyone come to actually justifying the law of sovereign immunity. However, the problems with that argument are too numerous to list here, so for brevity's sake, here are the biggest flaws with that argument. First, it only justifies holding the entire government immune from liability. It does not even arguably justify immunity for individual officers. Second, it does not justify when the entire government is responsible for the rogue officer's conduct, such as when the sanctioning bodies know about the misconduct and simply refuse to do their jobs. Third, and most of all, the fear of this happening, government producing inefficient services due to lack of funding, has no evidence to support it. It's pure fear-mongering and conjecture, nothing more. For example, the state of Washington has been without sovereign immunity ever since 1961. As anyone with half a brain can attest, the state of Washington has clearly not yet gone bankrupt or resulted in complete anarchy yet. How do you explain that? Washington state is not alone in this regard. While they are the only state in the USA to have waived its sovereign immunity, there are plenty of other countries that either do not have sovereign immunity or have a much more limited version of it than the USA does, and yet they still continue to be developed nations. For example, the constitutions of Denmark and Belgium both provide that while the king is immune from suit for his official acts, his ministers are accountable. Remember that, in modern times, the king has very little actual power to begin with. Therefore, immunizing him presents little danger to the everyday lives of his subjects. Meanwhile, the people who actually have the bulk of power in those countries, his ministers, are not immune from suit, according to those constitutions. And yet, both of those countries are not only still alive to this day, but are developed nations. In fact, the European Union collectively has an even greater GDP than the United States, according to the United Nations. Then there's Ireland. The Irish Supreme Court declared that sovereign immunity had been abrogated ever since 1922, when an Irish Revolution took place and the previous constitution was abolished. This means that Ireland has survived without going into bankruptcy or resulting in complete anarchy for nearly a century. In fact, nearly every developed nation except those derived directly or indirectly from English common law, or who simply aren't democracies to begin with, such as China, allow government agencies who hold 99.9999% of the power in their countries to be held accountable, and yet they continue to survive and effectively govern their people. Malaysia, Norway, Sweden, the list goes on and on. So the only argument that has come even remotely close to justifying the law of sovereign immunity, not only does it not even arguably justify 90% of what the law actually covers, but it isn't even supported by substantial evidence all over the world. There are exceptions to the law, at least in the 21st century. The most common exception is that the government officer's actions have to violate clearly established law. So, when I mention how cops will just make up charges, or how prison guards will beat and molest the inmates, in theory, there should be no bar to suing those people. Sure, you have to show evidence of a policy or custom before the entire local government can be held liable, but the individual officers? In theory, there's nothing stopping you from suing those cops unless the law was in some way ambiguous. And in the examples I gave in the previous sections, their actions were indeed against clearly established law. Then again, as we're about to discuss in the upcoming section, there's nothing stopping the judge from simply throwing the case out for no reason. Section 2-2 Judicial and Prosecutorial Immunity. Judging from the last section, I think we can all agree that sovereign immunity is evil. When I say all of us, remember that even the government itself, the people who have the most direct personal interest in justifying the law, do not even attempt to justify its existence other than because we can. So even the government itself admits that it is totalitarian and anachronistic. Well, if we all agree that sovereign immunity is evil and totalitarian, I think it flows naturally that judicial and prosecutorial immunities are 10 times as evil, 10 times as totalitarian, and 10 times as anachronistic. Why, you ask? Because judicial and prosecutorial immunities are absolute. At the end of the last section, I conceded that there were exceptions to sovereign immunity, the most common being if the government officer's actions violate clearly established law. For this reason, regular sovereign immunity is sometimes referred to as qualified immunity, because there is a qualification to it. However, judges and prosecutors have a special type of immunity known as absolute immunity. But wait, it can't possibly mean that, can it? Oh, yes it can, and it does. But don't take my word for it. Here are some excerpts from federal appellate and Supreme Court cases from all over the nation. The Fourth Circuit Court of Appeals in 1972, in the case of McRae v. State of Maryland, writes, "The absolute immunity enjoyed by judges is matchless in its protection of judicial power. It shields judges even in cases of malice or corruption." In 1978, in the case of Stump v. Sparkman, the case was mentioned in Title 1 of this video when I talked about a woman who was sterilized without her knowledge. The Supreme Court writes, "If a judge in a criminal court should convict a defendant of a non-existent crime, he would be immune." Remember when I mentioned how Mr. Lopez had a guilty plea entered on his behalf by the very judge who arrested and convicted him? Well, when he tried to sue that judge,
The federal courts just said that the immunity of judges applies even if the act was prompted by malicious or corrupt reasons, flawed by the commission of grave procedural errors, or taken in excess of jurisdiction. The court then went on to state that Vanderwater had an interest in the case. He prejudged the case, and he proceeded to judgment despite his knowledge of fundamental constitutional infirmities in the procedure that was followed. But that even grave procedural errors are not enough. Malice and corruption are similarly inefficient. Third Circuit Court of Appeals in the 2000 case of Gallus v. Supreme Court of Pennsylvania writes, "A judge will not be deprived of immunity because the action he took was done maliciously or in excess of his authority." What about prosecutors? They have absolute immunity too. In the 1976 case of Imbler v. Poxman, the Supreme Court declared that prosecutors have the same immunity as judges. You still think this is too outlandish to be true? Granted, unlike regular sovereign immunity, this time there is some effort by the government to try and justify this draconian law, if you could even call it effort to justify. Their argument has two main points to it. First, in 1967, in the case of Pearson v. Ray, the Supreme Court reasoned that allowing judges to be sued would result in the eventual downfall of the entire judiciary, effectively resulting in the destruction of government altogether because judges would be intimidated. We'll get to the second main point in a little bit, but first let me address just how stupid and lazily thought out the first main point is. There are a ton of little flaws in this argument, but most of them can usually be grouped into one of three categories. Flaw number one, lack of clarity. They say that allowing people to sue corrupt judges and prosecutors for their corruption would result in intimidation. Well, I ask you, intimidation of what variety exactly? There are different types of intimidation. Most of them, however, can be grouped into two basic categories: righteous enforcement and unrighteous terroristic threatening. The former is the type of intimidation that keeps you getting up every morning and going to work. You don't want to lose your job. You're scared of being fired. Your boss hovers that over you to not only keep you coming to work, but actually working when you're at work. Most governments specialize in this type of intimidation, or at least they pretend to. I'd like to think that some of us, including myself, obey the law simply because it's the right thing to do. But there are plenty of people out there who only obey the law because they are scared of going to prison, whether it's fear of being raped in prison or just fear of losing your freedom or having a criminal record. This type of intimidation is generally considered to be a good type of intimidation by the law-abiding, peace-loving citizens of our society. The general consensus is that without this type of intimidation, the world would just be pandemonium and anarchy. The strong could take what they want from the weak without any repercussions, and it would simply be a matter of might makes right and kill or be killed. What good is having law if there are no punishments for breaking the law? The second type of intimidation is terroristic threatening, and it is usually employed by mobs, terrorist groups, and even school bullies. It's because of this type of intimidation that the federal government has the Witness Protection Program. This type of intimidation usually entails not civil liability or a prison sentence, but usually just being gunned down by a drive-by shooter or having an assailant smash your window open with the intent of killing you in your own home. But more importantly than the method of death itself,
this type of intimidation usually involves a complete lack of due process of law. The assailant is acting entirely according to his own emotions and convictions, without any regard as to whether there is any evidence to support his claims, whether you had the legal right to do what you did, or anything else. He wants you dead, and that's all that matters to him. So when the Supreme Court says that allowing judges to be sued for their corruption would cause, quote, intimidation, just what type of intimidation are they talking about? Because if they're talking about righteous enforcement, then I ask, how is that a bad thing? That's the whole point of making them liable. But if they're referring to terroristic threatening, that transitions us to the second flaw. Flaw number 2, lack of evidence. Nearly every judge and politician in the nation will state over and over again that judges would live in constant fear of retaliation if they could be sued by the victims of their corruption. But you know what I haven't heard? Not once from even one single solitary judge, politician, or other government source? Evidence. Nothing remotely resembling any actual, objective, empirical, extrinsic proof that this would actually happen. Even the majority of the most popular conspiracy theories tend to have something resembling evidence to support their claims. Footage of the moon landing requires multiple light sources. The Twin Towers were falling at freefall speeds. The bullet that killed President Kennedy would have had to change direction in midair in order to also hit the governor of Texas. Most of these claims can usually be quickly refuted by anyone with even a little expertise in the field. However, they're also there. The conspiracy theorists at least try to give us something, however weak it might be, to go off of. Meanwhile, those who advocate for judicial and prosecutorial immunity offer nothing whatsoever to support their claims that allowing judges and prosecutors to be sued for their corrupt and malicious acts would result in the terroristic threatening type of intimidation. Instead, they feel as if the mere fact that they claim it alone, without more, causes it to become true. They don't need any evidence to support their claims, because their claims are the evidence. So they say that allowing judges to be sued for their corruption would result in intimidation of the terroristic threatening variety? Well, to that I say, why don't you prove it? Flaw number 3, lack of consistency. They claim that keeping judges and prosecutors free from fear of punishment is essential to a functional justice system. They claim that if judges and prosecutors were subject to personal liability for their corruption, they would live in constant fear of retaliation from every person they ever acted against. Frankly, I personally think that the citizens of this country are already living in constant fear of retaliation from angry judges and cops, but I've already discussed that in length. However, the government already has, on paper, methods for judges and prosecutors to be punished for their corrupt acts. They never are punished, as discussed in length in the first title of this video, but at least it's there, on paper. So, if they are worried about judges and prosecutors being intimidated, or living in constant fear, shouldn't they, by that logic, get rid of all possible consequences?
Couldn't the JCOs and ACOs of the various states impose consequences against judges and prosecutors just because they don't like them? Such as, oh, I don't know, disbarring any attorneys who criticize the judiciary? The only explanation that makes any sense is that they don't actually care about keeping judges and prosecutors free from intimidation or fear, but rather they just want sole discretion to decide who that intimidation and fear happens to. This would certainly explain how attorneys who criticize judges are so often and consistently disbarred. They don't want some righteous citizens to use those same tools against the corrupt establishment. Now, as I said before, I am a reasonable man. I am open to hearing another plausible explanation about why they would subject judges and prosecutors to this type of righteous enforcement, but not civil suits. If anyone else has an explanation, even a hypothetical one, then by all means post it in the comments. However, even though the explanation can be hypothetical, in order for me to entertain it, it would have to still make sense given all the evidence I've laid down thus far about how widespread the corruption is. But until I hear an alternative explanation that is even a little bit plausible, then my conclusion is that the government simply wants to have complete control over the intimidation that they claim is against the interests of an independent judiciary, solely for the purpose of protecting this corrupt institute. Speaking of which, that transitions us to the next section of this section. Remember, I said that there were two main arguments that the proponents of judicial and prosecutorial immunity offer in support of the draconian laws. The second argument is that there already exists sufficient measures to keep judges and prosecutors from being corrupt, not the least of which is the ability to have erroneous judgments corrected on appeal, as well as the ability of the JCOs and ACOs to punish rogue judges and prosecutors. They argue that self-regulation and professional sanctions from state bar associations are sufficient to deter misconduct, writes Huffington Post. By this point in this video, you should know full well that the second of these two measures is not good enough. Judges are removed from the bench extremely rarely, and prosecutors are removed even more rarely, in less than 0.4% of cases. So, they argue that subjecting judges and prosecutors to suit would cause them to live in constant fear of retaliation from their victims. Well, even if I had even a little sympathy for that argument, which I don't, that sympathy quickly goes away when the government has an alternative remedy at its disposal that, by all accounts, should negate the need to sue the judge or prosecutor, and then they just choose never to use it. The availability of appeal to correct errors is similarly inefficient to eliminate corruption. After all, like I said in section 1-1 and the analogy about the disobedient kid making the mess, the problem there is that judges are given no reason not to go ahead and give it the old college try. But even if you, personally, might be content with simply getting the corrupt actions overturned, and not necessarily seeing the corrupt judges or prosecutors punished for their crimes per se, appeal is still a joke of a remedy. Why? Because if somebody bribed the trial judge to rule in their favor, what makes you think they aren't going to simply bribe the appellate court to affirm their judgment and protect their investment? Seriously, come on, people. But even if you take all of that out of the equation, assuming for a minute that the courts of appeals were completely incorruptible, that they were superhumans who never made a mistake, that they always caught even the slightest of errors and always overturned them with 100% consistency and never was influenced by any corruption from any source. Appeal is still a complete joke of a remedy for corrupt acts. You know why? Because by the time they do that, you've already spent a good chunk of time in prison. Now, knowing that, does anybody want to try and tell me why that is preferable to ensuring that these corrupt acts never happen in the first place? Seriously, does anybody have any reason why it's preferable to let innocent people rot in prison first and overturn their convictions later? This is an open invitation. Please post a comment. I'd like to know. There's actually a third argument for the doctrine, but we'll get into that in the next section. So there is not even one single solitary argument in favor of judicial or prosecutorial immunity that makes any sense at all if you think about it for more than a second. Of course, those who are educated in the law, e.g. lawyers, who do think about it for more than a second and then proceed to speak up about their thoughts, get disbarred. But aren't we forgetting something in this section? Or rather, forgetting something in this title? Remember, the previous title was about discussing how bad the corruption is. This title was supposed to be about establishing how the corruption got as bad as it is today. So how does this section fit in Title 2 of this video rather than Title 1? Well, sit tight, because as we're about to discuss, the doctrines of judicial and prosecutorial immunity are actually recent creations. So recent, in fact, that there's a good chance some of you were alive before they were created. So recent, in fact, that one has to assume that they were created with the specific intent of covering up corruption. Section 2-3. Evolution of the corrupt system. A person who represents himself has a fool for a client, right? By this point, everyone accepts this as just a fact of life. What may shock you, though, is that this belief is almost as recent an invention as cars and the internet. Do you remember John F. Malloy? It's okay if you don't remember him. I've only mentioned him once or twice in this video so far. He's the judge who wrote The Fraternity 4 years before his demise. I mentioned him in Section 1-1 as an insider source to show that the practice of law functions fully as a bottom-line business. Well, his book contains a lot more than just that statement, and I encourage you to go and pick up a copy of that book and read it in its entirety. It's a fascinating read that this video only hopes to supplement, not replace. But for this section, I'd like to point out something else. The evolution of the current court system that requires attorneys instead of them being recommended but optional is actually a recent occurrence. Malloy actually explains that not 1 century ago, the legal system was actually fairly simple and easy to understand. Attorneys back then were more like mechanics are today. They can help you if you don't know how and or don't have the time to do it yourself. But if you can do it yourself, more power to you. Nobody suggests nowadays that you're in over your head if you try and fix your own car. And back in the 1940s, when Malloy first began practicing law, that was how self-representation in the courts was. But then, greedy attorneys and judges conspired to make the legal system excessively convoluted, with the express purpose of driving up demand for attorneys. Specifically, Malloy writes, "When I began practicing law in 1946, justice was much simpler. I joined a small Tuxton practice at a salary of $250 a month. Excellent compensation for a beginning lawyer. There was no paralegal staff or expensive artwork on the walls. In those days, the judicial system was straightforward and efficient. Decisions were handed down by judges who applied the law as outlined by the Constitution and state legislatures. Cases went to trial in a month or two, not years. In the courtroom, the focus was on covering and determining truth and fact. I charged clients by what I was able to accomplish for them. The clock did not start ticking the minute they walked through the door. Today, the skill and gamesmanship of lawyers, not the truth, often determine the outcome of a case. And we lawyers love it. All the tools are there to obscure and confound. The system's process of discovery and the exclusionary rule often work to keep vital information off limits to jurors and make cases so convoluted and complex that only lawyers and judges understand them. The net effect has been to increase our demand for lawyers, create more work for them, clog the courts, and ensure that most cases never go to trial and are, instead, plea bargained and compromised. All the while the clock is ticking and the monster is being fed. So as you can see, the evolution to the current system of widespread corruption discussed in Title I of this Act began fairly recently. But the foundation was laid for it to become as bad as Malloy explains almost half a century before Malloy began practicing law. Remember in the last section when I said there was a third argument for judicial immunity? Well, that argument is that judicial immunity, much like regular sovereign immunity, existed at English common law. Therefore, the logic flows that it should be treated as established law even if it is controversial. The burden of proof should lie on those who seek to change the status quo, not those who seek to maintain it. While I agree that the burden of proof should lie on those seeking to change the status quo, everything else in that last section is baloney. A Florida attorney named Robert Craig Waters writes for Cato Journal that judicial immunity at common law actually meant the complete opposite of what it means today. Let's see what he has to say. As early as 1613, English courts had recognized that Article 39 restricted the power of judges. Early English decisions had found that judges lost immunity from suits for acts clearly beyond their jurisdiction. Only in a single area did English common law grant a broad form of immunity to judges, recognizing a need to protect judges from the displeasure of the Crown and its ministers. The Star Chamber in Floyd v. Baker had held that a judge could not be prosecuted in another court for an alleged criminal conspiracy in the way he had handled a murder trial. In refusing to try the case, the judges of the Star Chamber held simply that if the king wished to discipline a judge, the king must do so himself without resort to criminal prosecution. Despite this narrow focus, Floyd frequently is cited as the foundation of the American judicial immunity doctrine. The federal court's lavish reliance on this Star Chamber decision is puzzling. While the immunity doctrine focuses exclusively on civil liability for judicial acts, Floyd is concerned not with liability, but with the proper method of disciplining alleged misconduct of judges. Indeed, Floyd's central concern is not judicial immunity at all, but judicial independence from the executive branch of government. The American constitutional system largely has resolved the problem that preoccupied the judges who wrote Floyd. The current American immunity doctrine not only was a serious departure from its common law antecedents, but also broke with early American case law. As early as 1806, the Supreme Court in Wise v. Withers had recognized a right to sue a judge for exercising authority beyond the jurisdiction authorized by statute. In 1869, 1 year after passage of the 14th Amendment and long before due process had assumed its modern contours, the Supreme Court made its first effort to define the limits imposed on state judges. The courts held that state judges possessing general powers were not liable unless perhaps when the acts are done maliciously or corruptly. Then, in 1782, 1 year after the civil rights laws were passed, the Supreme Court overruled its earlier dictum and announced that judges would not be liable even for corrupt or malicious acts. Now, for some of you, all that legal jargon probably went over your heads, made a full lap around the planet, and went over your heads again. So here it is in layman's terms. Back in English common law, judges were subject to suit by the people they harmed. Instead, they could not be punished by the king. Not by subjects, but by the king, for issuing rulings he didn't like. For about the first century in the USA, case law never questioned the precedent that judges could be sued for their corrupt or malicious acts. Judges could, and often were, held accountable in civil court. Then, in 1872, the U.S. Supreme Court overturned literal centuries of precedent and declared that judges were immune from suit even for corrupt or malicious acts. These people aren't simply misunderstanding a common law precedent and basing their case law on that misunderstanding. They are actively creating history for the express purpose of retroactively justifying their current actions. They are basing and justifying this totalitarian law on historical events that simply never happened. This, once again, reminds me of George Orwell's 1984. In the old days, it ran, before the glorious revolution, London was not the beautiful city that we know today. It was a dark, dirty, miserable place where hardly anybody had enough to eat, and where hundreds and thousands of poor people had no boots on their feet and not even a roof to sleep under. Children no older than you had to work for 12 hours a day for cruel masters who flogged them with whips if they worked too slowly and fed them on nothing but stale bread crusts and water. But in among all this terrible poverty,
there were just a few great, big, beautiful houses that were lived in by rich men who had as many as 30 servants to look after them. These rich men were called capitalists. They were fat, ugly men with wicked faces like the one in the picture on the opposite page. You can see that he is dressed in a long black coat, which was called a frock coat, and a queer, shiny hat shaped like a stovepipe. This was called a top hat. This was the uniform of the capitalists, and no one else was allowed to wear it. The capitalists owned everything in the world, and everyone else was their slave. They owned all the land, all the houses, all the factories, and all the money. If anyone disobeyed them, they could be thrown into prison, or they could take his job away and starve him to death. When any ordinary person spoke to a capitalist, he had to cringe and bow to him, and take off his cap and address him as Sir. The chief of all the capitalists was called the king, but it goes beyond making up history to try and retroactively justify this draconian law. To create this law, they had to completely usurp their legal and constitutional authority. They had to become legislators. According to the U.S. Constitution, all legislative powers shall be vested in a Congress. Although the courts have the authority to make case law, that case law is supposed to have to stay grounded in the statutes passed by Congress and the Constitution. The courts can interpret statutes, but they cannot create entirely new law from the ground up. Only Congress can do that. There is one exception to this restriction on lawmaking. That is when it is genuinely unconstitutional to not have the law that they are creating. We all know that the Supreme Court has the power to declare laws unconstitutional. This is called judicial review, and it's one of the most fundamental parts of the system of checks and balances. Well, it also works the other way around. The judiciary can create law from the ground up and/or force state and local governments to do the same if it is unconstitutional to not have that law. The most recent example of this happening is the controversy on same-sex marriage. Many states did not have statutes authorizing same-sex marriage. Many of them had statutes or constitutional amendments outright banning state recognition of the unions, but a handful of states had no law one way or another, so they merely defaulted to not allowing same-sex marriage. But that was only the default, not something that was mandated in their own laws. When the Supreme Court declared that same-sex marriage was a constitutional right, it forced all the states with laws banning the unions to revoke those laws. Again, that is common knowledge that the Supreme Court can do that. But it also forced states with no legal statements either way to create laws providing for their recognition. Other examples of this reverse judicial review, for lack of a better term, include the 1963 case of Gideon versus Wainwright, which stated that it is unconstitutional to force a defendant in a criminal case to proceed without counsel if he can't afford to hire his own counsel. This effectively forced several state governments to create entirely new, never-before-seen public defenders' offices. The 1966 case of Miranda versus Arizona created an entirely new, never-before-seen requirement for governments to recite the general rights to suspects and detainees. Now, what does that have to do with the corruption of today? Well, when the courts decided to create judicial immunity, they were not stating that judges and prosecutors have the constitutional right to be free from suit, or that somebody's constitutional rights would be infringed. Rather, they just decided that it was in the best interests of the nation to protect judges and prosecutors from suit.
That's Congress's job.
The Supreme Court's blatant usurpation of legislative authority is at its most blatant when it created prosecutorial immunity. At least with judicial immunity, the courts are at least pretending, even though it's complete garbage, that they are simply upholding centuries of established precedent. But in the case of Imbler versus Pochtman, the Supreme Court created prosecutorial immunity for the first time. In that case, they never pretended like there was any precedent for their actions. They were just creating a new, never-before-seen type of immunity out of thin air. Here is exactly what they wrote. This case marks our first opportunity to address the Section 1983 liability of a state prosecuting officer. We must now determine whether the same considerations of public policy that underlie the common law rule likewise countenance an absolute immunity under Section 1983. We think they do. If a prosecutor had only qualified immunity, the threat of Section 1983 suits would undermine performance of his duties. Can these people get any more shameless? Forget that their logic makes no sense. Forget that it has no evidence. Even if they had all the evidence in the world, it is simply not their place to make new law out of thin air, unless it is grounded in the Constitution. But don't take my word for it. Our favorite judge-turned-informant, John F. Malloy, agrees that the judiciary has usurped Congress's lawmaking authority for themselves. Our Constitution intended that only elected lawmakers be permitted to create law. Yet judges create new law in the judicial system based on their own opinions and rulings. It's called case law, and it is churned out daily through the rulings of judges. When a judge hands down a ruling, and that ruling survives appeal with the next tier of judges, it then becomes case law or legal precedent. This now happens so consistently that we've become more subject to the case rulings of judges rather than to laws made by the lawmaking bodies outlined in our Constitution. This case law system is a constitutional nightmare because it continuously modifies constitutional intent. For lawyers, however, it creates endless business opportunities. That's because case law is technically complicated and requires a lawyer's expertise to guide and move you through the system. The judicial system may begin with enacted laws. The variations that result from a judge's application of case law all too often change the ultimate meaning. They're the Supreme Court, so there's nobody above them to check or balance them, except for Congress, who can impeach them. But we learned in grade school that this almost never happens. So now you know the truth. The government of the USA became as corrupt as it is, not due to centuries of common law, but due to approximately 1.5 centuries of silent encroachments on the common law. Because nobody stopped them in 1872 when they had the chance, the encroachment continued and continued and continued until we got to the point where the judiciary accepts millions of bribes per year. Prosecutors and judges are almost never removed from their positions regardless of the evidence. Prosecutors will cover up evidence and have innocent people sentenced to death just to boost their win-loss records. Cops will routinely make up charges to arrest people they don't like. Guards will molest and beat inmates. Judges will make up laws they see fit based on whatever they want the law to be. And nobody, nowhere, ever does anything about it. Is there a way out of this living nightmare? Are we going to be forced to go to civil war against the government in an attempt to remove all this corruption? Actually, no. There is another way. Title 3. What we can do about it. Well, you've seen the evidence. You've seen that the corruption in this country affects just about every level of government, every branch of government, and nearly every government officer. The few government officers who aren't affected by the corruption are usually cast out and branded as incompetent, criminal-minded, or even corrupt themselves. But every dark cloud has a silver lining. I think it's time I stopped being so depressing with this video and started thinking positive. It's time I talked about the solution rather than the problem. Well, maybe a little more negative before we get to the real positive. Section 3-1. Methods that won't work. There have been attempts before to reform the government and make it less corrupt. As you can clearly see, none of them have prevailed. So before we get to the methods that will actually work, I propose we take a trip down memory lane and see what attempts have already been made so we know what not to do for ourselves. Number 1, asking Congress and/or legislatures to pass laws. Okay, for God's sakes, this should be a no-brainer. Yet people keep trying it. Okay, that's a bit of an exaggeration. There are 2 reasons this won't work. The first should be a no-brainer, but the second one is not as obvious. Here's the obvious one. If you contact your representative in Congress or the state legislature and ask them to pass laws that reform corruption in government, you might as well be asking them to blow their own brains out. There is a 99.99999999% chance that you will get absolutely nowhere, and a 100% chance you will not get what you want. The most likely scenario is that you will send this petition to them, and that will be the end of it. The politician will probably just ignore it, as if he never received it. Congressmen and legislators are required, under the First Amendment right to petition, to receive letters from their constituents, but they are not required to even so much as read those letters, let alone respond to them. They probably will at least read them, just to see what they're about, but once they realize that you're asking them to pass laws that will threaten their financial security, they will just toss those letters in the trash and never speak of them again in any way, shape, or form. If they do reply, they will probably say something to the tune of, they can't interfere in the judiciary in any way, directly or indirectly. That's a bald-faced lie, since we all know they can impeach judges. But what are you gonna do about it, huh? What are you gonna do about it? If you've got a problem with them lying to your face, why don't you do something about it? That's their mentality. I haven't gone into a lot of detail on legislative corruption in this video, but that's largely because there's not a whole lot I can say about the corruption of politicians that you haven't already heard a million times before, and I pledged to stay away from obvious stuff. But I will say this. Given all the corruption I've shown you in this video up to this point, we can all safely assume that any act of Congress or legislature would have little effect on the corruption that plagues this nation, no matter how well written the law was or how good its intentions are. Think about it. The problem in this country, as I've shown you, isn't that the law has loopholes that permit people to be corrupt. The problem is that government officers are just flat out breaking the law and not getting punished for it. What good is an act of Congress under these conditions? Statutes are just sheets of paper. But as the old adage goes, actions speak louder than words. Remember what I said earlier about the policy custom rule? It applies here too. What good is having a law if the rest of the government doesn't care and just ignores it? That is the second reason why petitioning the legislature won't work. Even if a miracle occurs and you somehow manage to get through to these people, if they are even people, I mean, they sentence innocent people to death just to boost their win-loss ratings, so are they people? What good is that going to do? What law could you pass that will actually succeed at lowering the corruption? Are you going to revoke sovereign, judicial, and prosecutorial immunity so you no longer have to rely solely on the JCOs and ACOs to keep officers in their place? Well, if they're going to bribe the conduct officers to exonerate the accused, what makes you think they won't just do the exact same thing to the judges in their corruption lawsuits? Are you going to take away the policy custom rule so government agencies can be held liable for hurting citizens regardless of what policies they have written down on a sheet of paper? Well then, what's to stop the government from simply bribing the judge into declaring that Princess Anderson's death, and by proxy the death of her unborn child, were in no way, shape, or form the government's fault? That Princess just spontaneously dropped dead of her own accord, a fact which the judge says is definitely proven beyond a shadow of a doubt by overwhelming objective evidence. Evidence he never discusses, but he says is there. And that her mother was nothing more than a frivolous filer looking to get rich quick. I could go on like this for hours, but I think you get the idea. The second reason why getting the government to pass reform laws won't work is because they don't mean anything if the very people charged with enforcing the laws themselves are corrupt themselves. Number 2. Asking the news media to raise a scandal. This is slightly less of a no-brainer than asking the legislature to intervene. After all, we're all raised to believe that an independent press can be relied upon for exposing corrupt government, right? Right? Go back and listen to that other sentence again. Take out the words to, all, we're, raised, that, and believe. After taking out all those words, you've got the version of that sentence you probably understood in your head when I first said it, as opposed to what was actually said. Quite frankly, I think it's a miracle I found as much evidence as I did for this video. If you go back and look at my sources, you'll notice that, with the exception of sections 3 and 4, police and prison, less than a fourth of all my sources come from privately owned and widely distributed news sources like the New York Times or The Guardian. The majority of my sources are from law journals, law universities, private charities, and published court opinions. Granted, these could be considered much better than private news sources, since they give an industry insider's perspective on the industry, but that's only a bonus. There just aren't that many sources from private major news outlets. The few major news sources I've used are probably the select few who are standing up to the bullies that are corrupt government despite knowing the risks. As I've demonstrated in Section 1-6, freedom of the press doesn't mean jack squat if the judges decide they don't like you. Remember Mark Mahon, who forbade the news from monitoring his cases? Look at what happened to Mark Thompson. He got arrested and charged with contempt of court, even though he was simply exercising his right to freedom of the press. Sure, these are one-off incidents, but as I explained at the end of that section, that's all it really takes to open the floodgates to 1984 levels of covering up corruption, as long as they're published opinions. Yep, it's time to look at that book again. Just once in his whole life, he had held in his hands unmistakable documentary proof of the falsification of a historical fact. It was a half-page torn out of the Times of about 10 years earlier, and it contained a photograph of the delegates at some party function in New York. Prominent in the middle of the group were Jones, Aronson, and Rutherford. There was only one possible conclusion. The confessions were lies. Even at the time, Winston had not imagined that the people had actually committed the crimes they were accused of. But this was concrete evidence. It was enough to blow the party to atoms, if in some way it could have been published to the world and its significance made known. Another example, he, O'Brien, said, "Some years ago, you had a very serious delusion indeed. You believed that three one-time party members named Jones, Aronson, and Rutherford, men who were executed for treachery and sabotage after making the fullest possible confession, were not guilty of the crimes they were charged with. You believe that you had seen unmistakable documentary evidence proving that their confessions were false. There was a certain photograph about which you had a hallucination. You believed that you actually held it in your hands. It was a photograph something like this." "It exists!" he cried. "No," said O'Brien. He stepped across the room. There was a memory hole in the opposite wall. O'Brien lifted the grating. Unseen, the frail slip of paper was swirling away on the current of warm air. It was vanishing in a flash of flame. O'Brien turned away from the wall. "Ashes," he said. "Not even identifiable ashes. Dust. It does not exist. It never existed." But there's a lot more keeping the majority of the news media scared of speaking out. Even if you take the risk of direct retaliation out of the equation, reporters are, in all likelihood, still acting out of fear of indirect retaliation. All of a sudden, court cases in which that media organization was involved would not go very well. People would show up and sue the newspaper for millions of dollars in seemingly unrelated cases and suddenly win, maybe even destroying and wiping out the newspaper. People at the newspaper might suddenly find themselves arrested and criminally charged for something that seems unrelated. Lawyers would be unwilling to defend the newspaper, or else only defend it badly, giving a victory to the other side. It might take a while, but eventually the newspaper might be totally destroyed by the legal machine, unless it learned its lesson of being submissive to the lawyers and judges. But even taking the possibility of illegal retaliation, direct or indirect, out of the equation altogether, there's still a matter of resources and time. In order for media coverage to truly succeed at curbing corruption, it would have to be continuously applied. The government will go right back to being corrupt if they are not under heavy monitoring by outside sources.
The news media simply cannot cover every single itty-bitty thing that every single government officer does. Every cop, every judge, every prosecutor, and every case. Expect every newspaper to be about 100,000 words each morning. You're simply asking too much out of them. Even if they had the resources to print everything, would you be willing to read it all? 100,000 words? Every single day? Are you willing to make that kind of a time investment? You have families to feed, you have jobs to go to. That last part is an essential element. The only reason the news media can be effective at uncovering anything is if said coverage reaches the people. Otherwise, they're no better than the random internet blogger who posts their videos back in 2007 and still has less than 1,000 views. News outlets are valued not because of the thoroughness of their coverage, but because of their ability to circulate. This, in all likelihood, is the main reason why I was able to find such ample evidence from industry insider sources like law journals. Nobody really reads them except for attorneys, and they're intimidated into silence in their own way. So the man probably doesn't hear those things getting circulated. Number 3. Protests a la the Occupy Wall Street movement. Oh my god. Here's another no-brainer for you. You don't need a PhD in corruptology to know that this course of action will go nowhere fast. First of all, as you can tell from section 1-6, the government is not even a little bit above arresting you and throwing you in prison if you try to disrupt their status quo. But even if you avoid being arrested, or even killed, like Sonny Shoe, there's still the matter of it not doing anything. What exactly are you telling the government they don't already know? That you want the corruption to stop? You're not honestly telling yourself that they don't know that already, are you? Mere words alone aren't going to force the government to do anything that they don't already want to do. You have to make them act. And there are ways to do that. Section 3-2. Methods that could work. So, you've seen that nearly any peaceful methods of reforming the government are destined to end in failure. But what about the methods that nobody ever thinks about, or nobody likes to think about? In this section, we'll discuss methods that could work, but are not guaranteed to. Potential method number 1. Rioting. In 2014, the citizens of Ferguson, Missouri rioted in the streets in outrage after a cop who had brutally gunned down an unarmed citizen was not indicted. The general consensus among locals in Ferguson is that this riot, unpleasant as it might have been, is what caused a number of reforms in their government. So writes the Huffington Post, were the riots costly and destructive? Yes, but reform never would have happened without the unrest. The protest, in many ways, worked. Those abusive municipal court practices, which many residents said had fueled widespread disrespect for authority, are being reined in. And the outcry spread far beyond the Midwest. In many ways, the Ferguson protests changed America. If not for the unrest, we wouldn't have seen municipal court reform. It's certainly a game changer, said Kevin Alba Brond, president of Missouri's Fraternal Order of Police and a member of the Ferguson Commission, created by the governor to correct economic and social conditions that fueled the unrest. Riots are scary, both for those watching them and those participating, because they could easily be gunned down by the National Guard, right? But it's the only thing anyone has tried so far that seems to get any kind of results. However, even if you survive the riots, and even if the government gives you what you want as a result of that rioting,
What exactly do you expect it to accomplish? What laws do you plan to get passed that will eliminate the corruption that caused the riots? Keep in mind, as I've demonstrated over the course of this entire video, the problem 99% of the time is not that the laws allow for the government to do bad things, but rather that the government officers know full well that what they're doing is illegal and are just outright breaking the law, and then they just don't get punished for it. No amount of clarifying the law or increasing the penalties for breaking the law are ever going to solve that problem. At that point, rioting in the streets becomes about as effective as media coverage. It at best can solve one case at a time, but there's little, if any, long-term reform. There's nothing stopping the government from just going right back to being corrupt as soon as the riots calm down. Potential method number 2. Running for local office yourself. Most of us never really consider the possibility of running for office ourselves. But why not? Is it because of how expensive it would be to run without partisan support? It's actually not very expensive at all. For example, using my state, Arkansas, as an example, how many signatures do you think you need to be put on the ballot for mayor? 10% of the voters in your 500,000 person city? Try 30. Not 30%. 30 signatures. As in a flat number. The maximum. Of course, getting on the ballot is one thing. How are you supposed to campaign without a ton of money? Well, you could always just spend your evenings and weekends going door to door, shaking everyone's hands and telling them what you're doing. That worked for Matt McMillan. His wife writes, "He told us that the Good Old Boy Club and George Brown would call in every political favor, pressure people, politicians, and businessmen, including the sheriff and law enforcement, to ensure Brown's campaign victory and our defeat. Silly, naive kids that we were, we ignored his advice and chose to knock on doors, 5,600 in all. Our opposition did everything to get us to quit except burn a cross on our front lawn. We were hit with spray painting obscenities on our front door, pelting eggs at our vehicles, middle of the night threatening phone calls, slashing our supporters' tires, a brick through our office windows twice, frivolous bar grievances, and local media smears like you wouldn't believe. We were permitted no interviews, no media coverage, and Judge George Brown received the endorsement of every organization, every politician, every newspaper, and every organization, including the Fraternal Order of Police and the PBA. We were not even interviewed before the endorsements were granted, violating many of the organization's written bylaws. The only supporters we had were the common people. The day of the election, the incumbent and his supporters in the Good Old Boy Club and the Bar Association spent the day blowing up balloons for his victory party. To their shock and amazement, Matt, we won the election. They were beside themselves, as the Good Old Boys had never lost control of an election. Of course, in order for this to work, you're all going to have to organize under a single leader. Famous political pundit Mike Moore actually capitalized on this aspect of human stupidity a long time ago when he was still in 12th grade. Since he was 18, he was allowed to run for public office. When he learned he only needed 20 signatures, as opposed to 30, in his state to run for school superintendent, he writes in his best-selling book, Stupid White Men, how his opponents fell into that trap. 20 signatures? That's it? I had no idea running for elective office required so little work. I got the 20 signatures, submitted my petition, and started campaigning. My platform, fire the high school principal and the assistant principal.
Alarmed at the idea that a high school student might actually find a legal means to remove the very administrators he was being paddled by, 5 local adults took out petitions and got themselves added to the ballot too. Of course, they ended up splitting the older adult vote 5 ways, and I won, getting the vote of every single stoner between the ages of 18 and 25. So get about 30 to 40 followers in your city. Ask them to sign you up for the ballot for mayor, and only you. Or if somebody else who's on your side wants to be mayor instead, just let them be mayor. This is no time to be fighting amongst ourselves. For example, if I were gathering about 30 other followers to nominate me for mayor, and somebody else was on my team who wanted to be mayor instead, I would argue that I should be nominated because I've spent the past decade fighting corruption, and I know what the signs are. Then I would let my opponent say his piece, and then the rest of us could all hold a vote. If the majority decided to nominate him instead of me, I would step down. What matters is the results we get, not that I personally spend the next 4 years living in the luxury and comfort that comes with holding public office. Once you're mayor, you can order all the cops, prosecutors, and local judges arrested. Mayor doesn't have the authority to remove judges or prosecutors from office, but they can still be imprisoned. It will be hard for them to ruin innocent people's lives from behind bars. But aren't we forgetting something? This method is being listed in the section methods that could work. There's a reason for that. Even if you win the election, don't think that the battle is won, and the bad guys are all suddenly going to be following your orders just because you're the one sending their paychecks for the next 4 years. Remember Matt McMillan? Well, that section where I talked about his victory, it wasn't an inspiring underdog story. It was the complete opposite. It was written by his wife, Susan McMillan, which kinda makes me wonder what happened to Matt. About the horrors of going up against the system. Even after Matt won the election, the bad guys didn't accept defeat, but rather they increased their persecutions tenfold. As the election results were coming in, witnesses overheard them vowing, "We'll see to it that McMillan never takes the bench." Yes, and they got to work right away. They filed grievances with the Judicial Qualifications Commission and the State Bar the day after the election and even before taking the bench, and have never ceased. Never mind that in the 3 years he has been on the bench, he implemented all of the legal reforms he promised. All of that was irrelevant. They set up a Star Chamber kangaroo court like no other. The charges bore little resemblance to the actual campaign literature they relied upon. The leaps of logic and twisting of words has to be seen to be believed. The courtroom citizens' observers were stunned at the guilty on almost all charges verdict, with recommendations for removal from the bench in spite of no evidence whatsoever of unfitness to serve and the overwhelming evidence to the contrary. Matt presented a stream of lawyers who regularly practiced in front of him, which testified what an outstanding judge he has been, and that they have never had reason to question his impartiality or fairness. The prosecution could produce not a single witness to testify that he was unfit. Chief Judge Tom Gallen, also a member of the Good Old Boy Club, who also had threatened my husband and I, admitted he had never observed my husband in court, was the Judicial Qualifications' only witness as to his lack of fitness. Talk about corrupt! When the rule of sequestration was invoked and Chief Judge Gallen was excluded from the courtroom during the trial as a witness, he ordered a county telecommunications worker to run secret microphone and video wires directly from the courtroom to his chambers so he could observe the trial before his testimony. The county worker who did the job came forward in the midst of the trial and testified of his orders by Chief Judge Gallen to run the wires to Gallen's office. But that did not stop the Judicial Qualification Commission from relying on this just as obstructing good old boy member as their only witness to McMillan's lack of fitness. Of course not.
Even after Judge Gallon was impeached on almost every statement he made, perjury and all, he remained their star witness. Truth and justice had no relevance. Their minds were made up to railroad Matt. It was a what need we of further witnesses proceeding. If anyone compares the record and trial transcripts with the findings, conclusions, and recommendations of the Judicial Qualifications Commission, they would sit in utter amazement and their mouths wide open. Of course, if you had been following the newspaper's version, whose editors also belonged to the good old boy club, you wouldn't be the least bit surprised. They portrayed Matt McMillan worse than Timothy McVeigh, Ted Bundy, and Danny Rollins all rolled into one for trying to clean up the legal profession and our impeccable judiciary. Wow. Just wow. So, if you want to be mayor so you can implement some reforms of your own, be sure to A. set up your own blog so you can counter whatever accusations the newspaper and local news stations make against you, because if you try to sue for libel, all your opponents will just say that you're no better than the allegedly corrupt officers you supposedly want to reform. B. Be prepared for a ton of harassment, including acts of outright terrorism from those who want to keep the government corrupt the way it is before you took office. And C. Expect quite a bit of mutiny from those who are supposed to be under your authority. But even if you can avoid, or don't mind, all of those things, we've still got the same problem as with rioting and or media coverage. You can only get these results for as long as you, personally, can continue to hold office. As mayor, you can ensure that the existing laws are enforced, but you have no real power to cause any long-lasting reforms without the city council cooperating with you. So, what's going to happen after you've served your second and final term? Is the next mayor going to just go right back to covering up the corruption in your city? If you want to create long-lasting, sweeping reform in this country, we're going to have to find another way. Fortunately, there is another way. One that only requires a handful of people to treat it like a full-time job, and one that only requires a monetary contribution of about $5 a month per person in order to sustain it. Ladies and gentlemen, allow me to introduce you to Section 3-3, the initiative method. What is the initiative, you ask? Well, as the name implies, it's the voters themselves taking initiative and bypassing the legislature altogether to pass the laws they want passed without any regard as to whether the billionaire politicians actually want it. For example, in my county, a few years before I started writing this video, the sale of alcohol was banned. It was called a dry county. Keep in mind, this was only a county-wide ban, so it was only required a modest amount of effort to travel from one county to the next to get alcohol. So the alcohol was still in the county, we just weren't getting any tax dollars from the sale thereof. So we had all the bad things about alcohol, but without any of the good things to balance it out. However, the county government vehemently refused to revoke the ban on the sale of alcohol, despite how pointless the ban was, because they personally felt that alcohol was evil. Granted, I admire their determination and willingness to adhere to their moral values without regard to material benefit. They almost have the right mentality. If only judges, prosecutors, and cops had the same attitude towards upholding the law regardless of how much money they're being offered to break it, or whether they like the person they're victimizing. But anyway, the people of my county realized that even if alcohol is evil, and maybe it is, it's still here, and we can't stop that. If we can't get rid of it, we might as well turn a negative into a positive and get some tax money out of it.
So, since the county legislative branch couldn't be trusted to see that reasoning on their own, the voters decided to do an initiative. The voters passed a law allowing the sale of alcohol within the county, and we've been raking in the dough ever since. So, what exactly is the initiative? Do a small group of registered voters just spontaneously decide that X is going to be the law from now on? No, actually. The process starts with only a handful of people. They draft a new law that they want to see on the books, and provide spaces for other registered voters to add their signatures. They then present this new law to registered voters. They either do this by going door to door, or by standing in a public high-density spot, such as the parking lot of a grocery store or a shopping mall, and then they ask passers-by to sign the petition. You have to collect a certain number of signatures. How many usually depends on one of two circumstances depending on which state you're in. How many people within the jurisdiction you're trying to pass the initiative are registered to vote, and how many people within the jurisdiction you're trying to pass the initiative actually voted in the most recent election. Either one can usually be told to you by either the county clerk or the state secretary of state. Anyway, you'll have to collect a number of signatures equal to or greater than a certain percentage of the voters. Again, the percentage you need varies from state to state, but it is almost never greater than 10%. Now, pay close attention to what I said just a moment ago. I said you needed signatures equal to or greater than a certain percentage. I did not say that those signatures had to be composed entirely of people who themselves had voted in the last general election. It is totally fine if the person standing in that parking lot collecting signatures registers a person to vote immediately before this person signs the initiative petition. Even though the county clerk didn't receive the registration until after the person signed the initiative petition, the fact that the registration was filled out before the initiative petition was signed is still good enough for the signature to be valid. So, what happens when you collect all the required signatures? After all, if the legislature isn't going to entertain your request to reform government corruption, can't they just ignore a petition of 1,000 signatures also? Actually, no! Not if it's an initiative! See, when you collect all these signatures, you're not submitting them to the legislature or governor. You're submitting them to either the county clerk or, if it's a statewide initiative, the state secretary of state. Once they receive it and confirm that it has all the signatures needed, then they have no choice but to place that law on the next ballot for a public vote. At that point, if the majority of the people vote to enact this initiative, then it becomes law, and the legislature gets diddly say in the matter. Granted, I encourage you all to pool your resources to hire the best professional help if you wish to use the initiative method to reform government corruption. Remember when I said at the end of that last section that this method requires only about $5 a month from each person? Well, you'll actually need that money from about 1,000 supporters if you want to make sure everything gets done correctly. For example, remember what I said earlier about using signatures of someone not originally registered to vote? Well, you have to be very careful to sign them up to be registered voters in the correct way, otherwise the county clerk will not accept your initiative petition, and it won't be placed on the ballot. I'm speaking from personal experience here, from a botched attempt by the people of my county to legalize the sale of alcohol before we had to try it again 2 years later. There are companies out there who specialize in overseeing an organization's efforts to pass a law using the initiative method and making sure that all their red tape is done correctly. You just have to find them. So now we have a plan. But just because we have the power to pass laws on our own doesn't mean that the laws we pass are gonna do anything. We have to make sure we actually tackle the problems we're trying to solve, in order to make sure we're not doing something completely unrelated. Just because our hearts are in the right place doesn't mean our efforts have any better chance of succeeding than any other methods I described in Section 3-1. So that begs the question. Section 3-4. What to include in the initiative. If we're going to pass an initiative to reform government corruption, we need to make sure we include the right provisions. We need to make sure that we're actually addressing the source of the problem. After all, just because we have good intentions does not automatically mean that an otherwise crackpot plan has any greater chance of success. This is why I spent the first 3.5 hours of this video discussing the problem in detail. I did not want anyone to be confused as to what will or won't work. If we're going to take this matter into our own hands, we need to know exactly what we're doing, otherwise we might just make the problem worse. So, without further ado, let's discuss what provisions we need to include in the initiative in order for it to truly eliminate corruption. I should point out that these suggestions are in no way, shape, or form intended to be binding on you. You can add, remove, or alter these suggestions at your sole discretion. It's your government, after all. It's more important that the government get reformed than my personal pet project actually get adopted. Number 1. Remove all immunity. As we discussed in Title 2, the floodgates for government corruption began many years ago when English common law said that the king could do whatever he wanted because he was the king. But in 1872, an already asinine legal doctrine was made 1,000 times more asinine when the Supreme Court decided to completely usurp the authority of Congress to create law, and to make up historical events to justify their actions. They decided to, in a completely unprecedented move, make judges and eventually prosecutors entirely above the law. As shown by John F. Malloy, that was the turning point for when the USA went from being a nation of the people, by the people, and for the people, to a nation where judges act as legislative, executive, and judicial branches all rolled into one. So, if we are going to pass an initiative to eliminate government corruption, the best place to start is to remove the foundation for that corruption. No longer can government officials, including judges and prosecutors, be exempt from accountability. You will want to especially include judicial and prosecutorial immunity when you're writing the initiative. Courts all over the nation have held that any laws which purport to create liability for government must actually state unambiguously that there is no immunity. Otherwise, sovereign immunity is presumed to still be kept. For example, there's a law in our nation called the Americans with Disabilities Act. Section 502 of that law states, "A state shall not be immune under the 11th Amendment to the Constitution of the United States from an action in federal or state court of competent jurisdiction for a violation of this section. In any action against a state for a violation of this requirement of this section, remedies, including remedies both at law and in equity, are available for such violation to the same extent as such remedies are available for such a violation in an action against any public or private entity other than a state." The Supreme Court has held this as a perfect example of how to unambiguously revoke sovereign immunity. So, if we are going to revoke sovereign immunity using the initiative process, we must do something similar. The best course of action
would be to have this be in a separate section from the rest of the provisions we'll be discussing in this section. The section should probably look something like this. Paragraph A. All governmental immunities from suit within this state are hereby revoked, including, but not limited to, qualified immunity, 11th Amendment immunity, judicial immunity, prosecutorial immunity, legislative immunity, or any other immunities which may or may not have historically protected any government officers. Paragraph B. This shall include immunity from any types of relief, including but not limited to equitable relief, punitive damages, and any intangible damages. All government officers, including police officers, judges, prosecutors, legislators, and even the governor, shall be fully liable to any person who they unlawfully harm for the full amount of their injuries. Paragraph C. The state shall be vicariously liable for the acts of its employees to the same extent as the individual officers were also liable. Notice how I didn't make any references comparing the liability of government officers to those of private officers, like in Section 502 of the Americans with Disabilities Act. There's a reason for that. Courts have held that if you use that language, then the waiver of immunity does not apply to acts which are exclusively governmental in nature, such as prisons. After all, in those circumstances, private citizens would have no obligations at all, and therefore, to hold the government liable the same as private citizens would mean that they're not liable in the first place. Makes sense, right? The case law on this issue has, admittedly, gotten better in recent years, but if you're following my wisdom, I would recommend not giving them that foothold in the first place. You can bet your bottom dollar that the government will vehemently look for any excuse it can to avoid being held accountable. Number 2. Mandatory video footage and keylogger software. This idea is rapidly gaining steam in various places across the nation, but as I've already explained, there's a loophole in those laws big enough to land a plane in. If they can just happen to not have the footage, for whatever reason, then you're SOL unless you can somehow manage to prove that the cops themselves deleted the footage on purpose. To ensure that this doesn't happen, we should make it so that the camera footage must be produced in any circumstance where it is relevant evidence. For example, anytime there is an arrest, the cop must attach video footage of all the evidence he observed that led to the arrest decision. Not just photographic evidence, but video footage. The footage has to show the cop walking over to the couch in real time and pulling off the couch cushion to reveal the 5-pound bag of cocaine. Having a photograph doesn't count. However, I highly recommend requiring all government officers, not just cops, to carry this footage. After all, as I've shown you, police are only part of the problem. In fact, compared to the massive amounts of judicial and prosecutorial corruption, they're actually a fairly tame portion of government corruption. If we want government as a whole to get better, we need to force all the government officers to carry the footage. We need to be able to see the judge enter into agreements in real time to rule in the defendant's favor if we are to truly hold the judge accountable. We need to see the prosecutor take the crime lab report and remove a page from it if we are to prevent innocent people from being sent to death row for decades at a time before the Brady violation finally shows itself. The only way to do that is to force everyone, not just cops, to have video footage of their activities. The footage should have to be kept for at least 10 years. Why so long? Because that eliminates the possibility that the government could allow new footage to simply record over the old footage before the citizens have a chance to request it for use in their own court cases. You might think this would become so expensive that it almost isn't worth it, but you'd be wrong in that respect. The footage does not have to be very high quality. In fact, I think VHS quality would work just fine. For those of you too young to remember VHS, try watching a YouTube video at only 240p resolution. Sure, it's not as good as 720p or 1080p, but at least you can tell what's happening. If you're investigating whether the cop arrested the civilian for no reason at all, only to make up stuff in the arrest report, do you really need to see the individual beads of sweat trickling down the suspect's neck to get to the bottom of that case? VHS quality video, when in the form of a computer file, usually has a file size of a single megabit per second. Notice I said megabit, not megabyte. A megabit is 1/8 the size of a megabyte. So a megabit is 128 kilobytes. That means that, over the course of 24 hours a day, 366 days a year, we come out to approximately 4.14 terabytes of data storage per year per camera. As of the time of this writing, you can get a 5 terabyte hard drive for approximately $350, and that's if the hard drive isn't on sale. That's enough hard drive space for an entire year's worth of footage, so that effectively amounts to less than $30 per month per camera. I think the government can afford that. In fact, the state probably doesn't even need to raise taxes to do this. I think individual cops and judges who tend to get paid six figures could afford to take a loss of $30 per month for the next 10 years, while they each provide for the hard drives to store the camera footage for their actions. But if we're going to force government officials to keep the footage so they can never lie about anything, we have to do something to ensure they don't delete the footage without us being able to prove that the deletion was done on purpose. Here's my suggestion. Make it totally irrelevant if the footage was deleted on purpose or not. If they don't produce the footage when that footage is relevant, they lose the case. Period. They lose the lawsuit when they're sued. If they arrest someone and don't attach footage of the investigation to the arrest report, like in the above example with the cocaine, the defendant goes free. Even if the loss of footage was a freak accident. Even if they could prove that it's an accident. Not just challenging you to prove that they did it on purpose. It doesn't matter. No footage, they lose, the end. And that's all there is to it. Now, this does run the risk of courts being forced to let criminals walk free. However, the problem is no worse here than it is when evidence is suppressed because it was acquired in violation of the defendant's Fourth Amendment rights. We accept that as a necessary evil because we understand that protecting citizens from unwarranted invasion of privacy is more important than catching a single bad guy in a single case. Well, in this case, it's entirely within the government's control whether they attach the footage. And in the event the footage does go missing, and not that they simply deleted it, it's still entirely in their control what quality of camera equipment and hard drives they use. So anytime the cops or prosecutors don't have or can't find the relevant footage, that is, guess whose fault? No, not the queers. It's the cops and lawyers working for the government. Come on, people. So, what should this provision look like in terms of statutory language? Here is my recommended text. Paragraph A. All government officers who have any discretion in the performance of their duties must keep video footage of all their activities at all times, even if it is not while they are on duty. The rooms of all government buildings must have every angle of their interiors monitored by security camera footage at all times, 24 hours per day, every day. Paragraph B. All footage must be of VHS quality or greater, and must record all incoming audio with equal or greater quality. Paragraph C. All computers owned by government agencies or government officers, including pocketable computers such as smartphones, must have all of its activities and input recorded using keylogger records. Paragraph D. All telephones owned by any government officers or government agencies, including those used exclusively for personal use, must have every call recorded. Every word that is spoken between the two phone lines must be recorded, and the phone numbers being called must also be recorded. Paragraph E. All footage, keylogger records, and phone recordings must be public record unless sealed. Any unsealed video footage, keylogger records, or personal phone recordings must be available for viewing and download on a website accessible from any standard computer with a standard web browser. No citizen may ever, under any circumstances, be charged any costs for viewing or downloading this footage. In no event shall any citizen's browsing activities while on the site be monitored without his express written consent, and in no event shall consent to being monitored ever be a condition for accessing the video footage or keylogger records. Paragraph F. Footage, keylogger records, and phone recordings may not be sealed under any of the following circumstances. 1. If the footage depicts the interior of any government building or government-owned vehicle, regardless of what time of day it is. 2. If the footage depicts any actions of any government officer while they are on shift or at work, even if they are not actively engaging in any government function. 3. If the footage, records, or recordings depict the government officer in any way, shape, or form performing or discussing the performance of his job duties, performance, or activities. 4. If two or more government officials are interacting with each other in any way, unless they are biologically related to each other or married to one another, and are not discussing anything related to their jobs in any way, shape, or form. However, footage may be sealed in any of the above scenarios if the sealing is necessary to protect the anonymity of a private informant or protect the confidentiality of an attorney-client privilege or doctor-patient privilege. Paragraph G. When making an arrest, the arresting agency must attach all footage of the evidence he observed that led to the arrest. Failure to do so must result in the defendant being discharged of his charges. Paragraph H. All footage, keylogger records, and phone recordings must be immediately produced in any legal proceeding, judicial or otherwise, that it might be relevant evidence in. Failure to do so must be adequate grounds, without more, for disqualifying the government officer from that proceeding and awarding a victory by default to the opposing party, regardless of what other evidence or extenuating circumstances may be present. Paragraph I. There are no exceptions to the application or enforcement of this section or any defenses to the violations thereof including that the opposing party never requested the records, that the footage was lost inadvertently or otherwise, that the footage would have had little or no evidentiary value, or that the government officer believed, in good faith or otherwise, that the footage was not relevant evidence. Paragraph J. If any footage, keylogger records, or phone recordings are not kept in accordance with this law, if it is less than the required quality, or if it is lost, even if it is lost inadvertently, then the government officers who should have been depicted in that footage, or the government officers who should have had control over the computer or phone, shall be sentenced to no less than 10 years in prison. There shall be no maximum sentence for failure to keep or produce the footage, recordings, or keylogger records, and any person sentenced under this section may receive any punishment, including death or life in prison. Number 3. Ban government lying. As I discussed earlier, this is the one that tends to do the most indirect damage. While lying does little harm to people directly, at least when people don't believe the lie, when citizens believe that the government is telling the truth, or choose to accept the government's word out of fear of the alternative, that sparks a chain reaction that causes massive amounts of indirect damage. So the best course of action to take is to forbid government from lying altogether. Unlike with the video footage, there would be a few exceptions to this rule. I like to refer to this exception tongue-in-cheek as the Santa Claus, because that is the best example I can come up with about when this exception would be applicable. The exception is like this. A lie from a government officer would be allowed if the following conditions are met. 1. The lie is told exclusively in his personal capacity, not as part of his job as a government officer. 2. The lie is typically a socially acceptable one. And 3. Nobody is harmed as a result of this lie. I call this exception the Santa Claus because lying to children about Santa is one of the biggest examples I can think of when this exception would apply. The lie is told as a purely personal and intra-familial matter having no connection to their jobs whatsoever. The lie is a socially acceptable one, as evidenced by how pop culture and news media routinely play along with the act. The third and final element is a little harder to pin down, but the evidence is still there. Numerous studies have been done on children who recently learned that Santa wasn't real, questioning whether they felt any sense of anger or betrayal over the deception. The answer to that question, these studies have found, has been a resounding no. However, lies that are personal, but where somebody is harmed by the deception, such as lying about an affair you had with your intern so your wife doesn't divorce you, would not be covered by this exception. But enough about the exception, let's talk about what it covers in the first place. Well, obviously it would cover anything not covered by the exception. This obviously means that there would be no requirement that the lie be under oath, such as perjury, or when you were given direct orders to lie. But what about less obvious stuff? For starters, what even counts as a lie in the first place? Obviously, giving a statement you know full well to be false would fit squarely within that definition. But what if you just don't disclose information that leaves people with a misconception? Does that count as a lie? What if you make a statement without knowing whether or not it's the truth? E.g., if you just don't look it up first before you say it. Does that count as lying? Should you have to disclose to your audience that you made no effort whatsoever to verify these facts, like I did earlier with my theory about why prison guards are so corrupt? What if the words themselves are not false, but the tone suggests sarcasm? Like, if a government officer is confronted with an accusation, he might respond by saying, "Oh, yeah, that's right. I arrested that guy just because he is black, 'cause I'm just racist that way." Does the tone itself constitute a lie? The best way to avoid long, expensive legal battles is to provide a catch-all definition. Legal definitions are not the same as ordinary definitions. When we create a legal definition of something, the lawmakers, or us in the case of an initiative, can make that definition whatever we want. If the law in your state says that your middle finger is a deadly weapon, then it's a deadly weapon. The legal definition doesn't have to bear even the slightest resemblance to the common definition of something if the lawmakers don't want it to. The only requirement for a legal definition is that it has to have completely objective terms. If a person of normal intelligence cannot clearly identify whether a particular object or scenario falls within a legal definition, that legal definition is considered void for vagueness under existing constitutional law. So, what should we have as the legal definition of a lie? Well, here's my proposed text for the initiative that bans lies. Paragraph A. Any government officer who lies about any topic to any extent shall be liable to all those harmed directly or indirectly about the lie, and shall suffer a criminal penalty no less than 10 years in prison with no maximum sentence. Paragraph B. Lying for purposes of this law shall include any act or omission whatsoever which is intended or has any tendency, regardless of its intent, to cause any person, regardless of gullibility, to believe something that is not true, assuming they believe the speaker, including, but not limited to, failing to disclose information that could leave any person with a misconception, or manipulating any communication besides words, including, but not limited to, tone of voice and or body language, to imply the intended message is not consistent with the speaker's words. Paragraph C. It shall not be a defense to this law that the speaker made his false statements without knowing in advance whether the statements were true or false. It shall not be a defense if nobody believed the speaker. Paragraph D. However, it is a defense if the speaker relied on a source the speaker reasonably believed to be reliable, only for its lack of reliability to be exposed at some point after the statement is made, and the statement is corrected as soon as possible after the lack of reliability is exposed. Paragraph E. It shall also be an exception if the lie was told in a purely personal capacity, is a socially acceptable lie, and no person was harmed as a result of this lie. Paragraph F. It is also a defense if the deception is necessary for the performance of an important government function, including, but not limited to, military tactics and police undercover operations. However, this defense is only applicable if the government function cannot be performed at all without the deception. The defense is not applicable if the government function cannot be performed as effectively without the deception. Paragraph G. In
all exceptions and defenses, the government party telling the lie shall hold the burden of proving each element of the exception beyond a reasonable doubt. Paragraph H. There shall be no exceptions to this law except those which are specifically listed herein. Notice how paragraph B provides a definition that cannot possibly be manipulated. If any person, no matter how gullible they are, might believe something, anything, that isn't true because of your statement, then that statement is a lie. Period. It doesn't matter if the lie failed. It doesn't matter if they use some sort of manipulative tactic to make the audience believe it without actually lying directly. Nothing matters. Your statement or your implication is false. You go to prison. End of story. Paragraph D protects those who do their best to tell the truth but end up lying by accident through no fault of their own. However, they still have to correct their mistakes as soon as the mistakes become apparent. If they don't, that's just as bad as omitting information. It's not a get-out-of-liability-free card. They still have to put forth some effort to make their statements true. In only a few short paragraphs, I have managed to eliminate nearly any form of government deception except those where the deception is necessary in one fell swoop. But what about when the government doesn't give false information, but rather just doesn't give information? Number 4. Ban summary dispositions. As we discussed in Section 1-7, this is one of the easiest tools the government has at its disposal to cover up their corruption, since it requires more effort on their part to try and give an explanation for their actions than to not give one. Since it's so easy to use, we should get rid of it. So here's my recommended text. Paragraph A. In all proceedings, judicial or otherwise, the tribunal must provide specific findings of fact and specific conclusions of law for every decision he makes. All findings of fact must be supported by evidence on the record, and all conclusions of law must be supported by at least one specific legal citation. Paragraph B. It shall not be a defense to this law that the fact or law is obvious or well known. All arguments and counter-arguments raised by all parties must be specifically addressed in the above-styled manner, with findings of fact supported by evidence and conclusions of law supported by legal citations. It is not a defense to this requirement that the argument raised by the parties is frivolous. Paragraph D. This provision shall not require a jury in a court proceeding to issue an explanation for its verdict. Paragraph E. Any violation of this act shall incur a penalty of no less than 1 year in prison for every argument that is not addressed, for every finding of fact that has no evidence to support it, and for every conclusion of law not supported by a legal citation. Paragraph F. Any order from any government tribunal except a jury, including judges and administrative review boards, with no explanation whatsoever, shall incur a penalty of no less than 40 years in prison, with no maximum sentence. Paragraph G. Any tribunal who violates this act shall never again be eligible to serve as a public officer. Now, why would I include that last sentence in paragraph C? Do I believe in allowing people to bog the court system down with frivolous lawsuits? Of course not. There are plenty of ways to punish parties for raising frivolous claims that don't require their claims to go unaddressed. What I'm trying to do is to stop corrupt courts from ignoring arguments that are so powerful the judge can't find a way to rebut them. Then they just say that the argument is frivolous even though it's not. Granted, I feel like making such a declaration would still be a violation of paragraph A. However, just like with the waiver of sovereign immunity not making any comparisons to private liability, I don't want to give them the chance. This is not an unreasonable requirement. The judges are not being terribly inconvenienced by having to explain their decisions. In fact, this is entirely consistent with what we've been taught as little kids. Think back to when you were a kid taking a math test. 99% of the time, except maybe in the case of one-digit multiplication problems, it wasn't enough that you simply got the correct answer. To earn full credit on your test, you were required to show your work. When we grew up and went off to college, a similar policy was hammered into our heads. Regardless of your major, you are guaranteed to take English composition in your first semester. At least for me, personally, my instructor in that class never shut up about the importance of citing your sources. Forget learning how to do a thesis statement or structure your main ideas. More than anything else, knowing how important it is to cite your sources is the most important thing I learned in that class. Or at least that's how the instructor made it seem. So as you can see from those two examples, this section of my recommended initiative is not requiring the judges to do anything that they haven't already been forced to do at some point in their lives, by government-employed overseers no less. This ensures that no court will ever be able to protect their corruption by eliminating any means the parties have of finding evidence of corruption. The judges have to give explanations, and in doing so, run the risk of parties reading between the lines and finding inconsistencies in their logic and therefore evidence of corruption. Number 5. No more presumed harmless error. Do you remember the harmless error rule? Do you remember how it applies in even the most ludicrously prejudicial of situations? However, you might also remember that the harmless error rule does indeed have its place. It isn't a completely totalitarian law like sovereign immunity. There are situations where it is justified. If you want my opinion, we shouldn't get rid of the harmless error rule entirely. We just need to tame it so that it can't be used to protect corruption. So here's my proposal. Make it so that the burden of proof of harmless error lies on the party who advocates for it, not the party seeking to get the judgment reversed. My recommended text of that legislation? Paragraph A. No error in the judicial process shall be affirmed unless it can be proven beyond a reasonable doubt that the judgment would not have been affected in any way, shape, or form without the error. Paragraph B. A judgment shall be affected by an error if anything about the legislation, including the sentence, charges convicted on, or any other aspect of the judgment, would have been even slightly different. To succeed on this defense, the advocate must prove beyond reasonable doubt that the outcome of the case would have been exactly the same in every conceivable way, even if the error did not occur. Just in those two paragraphs, I've reformed the harmless error rule from a tool used to cover up corruption to a tool to exactly what the harmless error rule should be, preventing cold-blooded killers from escaping justice in the face of overwhelming evidence just over the stupidest of slip-ups on the prosecution's part. But it cannot be used for anything other than that. Number 6.
set limitations on police interrogation procedure. You may recall from Section 1-3 that police use a variety of tactics to get you to confess, even when the evidence they have against you is flimsy, just so they don't have to admit they were wronged. However, a good chunk of these methods can usually be easily defeated simply by banning these methods. So, I propose we do exactly that. My recommended text is thus. Paragraph A. All persons subject to interrogation by police must be provided counsel for the entirety of their interrogation unless they freely and voluntarily waive the right to counsel in writing. Paragraph B. No person in police custody may be interrogated except during the hours of 8 a.m. to 12 p.m. and the hours of 1 p.m. to 5 p.m. No person may be subject to interrogation on either Saturday or Sunday. No person may be interrogated for more than 40 hours for any case he is a suspect in. In the event that the citizen is a suspect in more than one case at a time, he shall be exempt from interrogation for 90 days after the conclusion of the aforementioned 40-hour quota. Paragraph C. The suspect must be provided a reasonable amount of food and water in between the events of 7 a.m. and 8 a.m., in between the hours of 12 p.m. and 1 p.m., and in between the hours of 5 p.m. and 7 p.m. The suspect must be provided lodging and accommodations of reasonable comfort when not being interrogated. Paragraph D. During interrogation, the suspect must be provided a chair equal to or greater in cushion to that used by the jail's warden in his primary office. The room housing the interrogation must be regular room temperature and must have a reasonable amount of decoration on the walls. Light must be evenly distributed across the entire room. Paragraph E. Only one officer may interrogate the suspect for the entire duration of the interrogation. However, other officers may be present to physically prevent the suspect from attempting to leave or committing any crime. The interrogator must, at all times during the interrogation, remain seated directly in front of the suspect and no less than 10 feet away from the suspect. Paragraph F. During the interrogation, the interrogator may not use any body language of any kind. He must maintain a monotone voice at all times, regardless of his personal, subjective emotion, and may never speak louder than 60 decibels. Paragraph G. The interrogator may never say anything to the suspect except a question or a command to view evidence. A command to view evidence may not be issued by the officer unless the officer can show the evidence at the moment he issues the command. Paragraph H. If any of these provisions are violated, the officer who violates them shall be sentenced to no less than 10 years in prison with no maximum sentence, and may never again work in any capacity for the government. Meanwhile, the suspect being interrogated must immediately be set free and all pending charges against him dismissed, regardless of what evidence the state may have against him. With this law, the police cannot use good cop, bad cop interrogation methods. They can't lie about evidence. They can't hold you indefinitely without food, water, or sleep until you can't take it anymore. They can't wear you down by shining a bright light on you. They can't subject you to sensory deprivation. They can't threaten you with their posture, or by growling, or yelling, or by warning you of the dire consequences of not confessing. Most of all, breaking this law will carry serious consequences, not just for the individual officers, but for the entire criminal justice system as well. Number 7. Force the jurors to be selected randomly using computers. You may remember back in Section 1-7 when I mentioned how this can be used to corrupt the jury, which is supposed to be the one last failsafe against corruption. So, to keep this from happening, we need to force the clerk to use a method of summoning jurors that forces the selection to be random. It has to be set up in such a way that the clerk physically can't summon preferred jurors even if she wanted to. While we're at it, it has to be a method that can still be traceable. That way, if the clerk tries to use some other method of summoning the jurors, the parties will instantly know about it. Otherwise, requiring this method would be pointless. Computers provide the best way to do this. They can be traced using the keylogger software mentioned earlier. Meanwhile, we can ensure that the clerks are unable to summon preferred jurors by forcing them to use software that necessarily summons them at random. So, here's the recommended text for this section. Paragraph A. All clerks of the court must, when summoning registered voters to jury duty, use computer software to determine which registered voters will be called. This software must select the voters at random, with each registered voter having an equal chance of being selected. The settings for the footage, to the extent they can be altered, must not allow any person to increase even slightly the odds of any voter being selected by the random selection. Paragraph B. When the voters have appeared for jury duty, the clerk must use similar or identical computer software with identical settings to randomly select the voters to be called to the voir dire. Paragraph C. The records of the software used in the above two paragraphs must be published using the keylogger records the government is required to keep. Paragraph D. If the clerk uses any other methods for summoning voters to jury duty or summoning jurors to voir dire, the clerk shall suffer no less than 10 years in prison with no maximum sentence. Meanwhile, the case in which the voters were supposed to be summoned must be immediately stopped, and all parties must be compensated by the state in the same manner as if the state's corruption had caused that party to lose the case. However, the state shall not be required to compensate any party in accordance with this section if they can prove, beyond reasonable doubt, that this party personally participated in the manipulation of the jury selection process. Paragraph E. It is not a defense to a violation of this section if the violation was harmless. Number 8. Make enforcement mandatory against corruption. As I've demonstrated numerous times over the course of this video, the legal system usually has one final fail-safe against those who wish to fight corruption. Simply sitting on their butts and not doing their job. Well, imagine if we made that against the law as well. JCOs and ACOs were required to sanction anyone under their jurisdiction who violated the law. Prosecutors were required to charge cops, lawyers, and judges who broke the law unless they had good reason for not doing so. State legislatures were required to impeach judges who break the law. In Section 1-6, I mentioned how Florida Judge Mark Mahon ordered the arrest of anyone who calls the judicial system corrupt. Well, imagine if he was the one arrested for issuing this order, not the people. efforts to curb free speech would not last long, would it? So here is my recommended text for this section of the initiative. Paragraph A. Any police officer who knows of a judge issuing any order within his jurisdiction that he knows is unconstitutional or motivated by any corrupt motives must arrest that judge at the earliest possible opportunity. Any police officer who knows of a prosecutor or other attorney acting in violation of any law within his jurisdiction must arrest that attorney at the earliest possible opportunity. Any police officer who knows of any other police officer, including his commanding officer, committing any crime or engaging in any conduct with corrupt motives must arrest that officer at the earliest possible opportunity. It is not a defense to a violation of this paragraph if the officer to be arrested is higher on the chain of command. Paragraph B. Any legislator who knows, through whatever means, that any judge or prosecutor has engaged in any illegal activity, or who has engaged in any activity for any corrupt motives, must initiate impeachment proceedings against that officer at the earliest possible opportunity. The legislature must then unanimously agree to remove that officer from office. Paragraph C. Any judge who is aware of any illegal conduct occurring in any proceeding in which he presides must issue immediate sanctions to the offender sufficient to ensure that the conduct is not only discontinued, but will never occur again. It shall not be a defense to this paragraph if the judge feels, without any substantial evidence to support it, that the error can be corrected without sanctions. However, nothing in this paragraph shall require the judge to independently investigate the facts of a case. Rather, the obligation to enforce the law exists if the judge learns of any misconduct, with or without personally investigating the matter. Paragraph D. Any prosecutor who has probable cause to convict any government officer within his jurisdiction must charge the officer with that crime. It is not a defense that the prosecutor has a conflict of interests. Paragraph E. The Judicial Conduct Office must punish any judge they know to have violated the law. The punishment must be severe enough that it ensures such conduct will never happen again. The Attorney Conduct Office must punish any attorney they know to be in violation of the law. The punishment must be severe enough that it ensures that such conduct will never happen again. Paragraph F. The governor must order the arrest and prosecution of any government officer, including police, prosecuting attorneys, judges, legislators, or anyone else who violates any citizen's rights under color of law. Paragraph G. Any officer who fails to discharge his duty of law enforcement pursuant to this law shall be liable to any citizen he injures as a result of this failure for the full range of damages a citizen would normally be liable for, including but not limited to intangible damages and punitive damages. The state shall also be vicariously liable for the same damages. Number 9. Reward the turning in of bribes. As I've demonstrated in this video, there are an astronomical level of bribes in this country. The biggest reason behind this level of bribes is because there really isn't much reason to not accept the bribes. Since the judge isn't going to get removed from office, what's the worst that could possibly happen? There's no incentive to not take the bribe. So, I propose we make an incentive to do so. We should offer a reward to any person, including private citizens, more on that in a minute, who turns in another person's attempt to engage in any corrupt act, including bribery. Now I know what you're thinking, but didn't you already propose a law that makes a person able to recover damages if the government doesn't enforce the law? Doesn't that remove your argument about there being no incentive not to take bribes? I did, and if that law always goes off without a hitch, that should be all we need. However, as Mythbusters once so eloquently put it,
you should never, ever, ever expect Plan A to go off without a hitch.
I've proven that multiple times over the course of this video. Methods of holding government officers accountable exist all over the place in the law books, but they almost never work. If we truly want to end all this corruption, we need to attack corruption from every conceivable angle, leave no stone unturned, and make sure we can tackle every possible opening for the government to be corrupt. After all, as the saying goes, water will find a crack. We have to make sure the government simply has no means of being corrupt, no matter how hard they look. So, here is my recommended text of the law to pass. Paragraph A. Any person who has evidence of any act of government corruption, and who discloses that evidence to the Attorney General, shall be entitled to receive from the state a reward no less than 3 times the monetary value of the corruption he exposed. However, in no event shall this reward be less than the spending power of $50,000 in the year this law was passed. This reward shall be paid by the Secretary of the Treasury and must be tendered within 30 days after the evidence of the corrupt act is revealed. Paragraph B. It shall not be an exception to this act that the person revealing the corrupt act was not in any way, shape, or form a part of the corrupt act, or had any duty to enforce the law. Paragraph C. However, no person may receive any reward for exposing any corrupt act if criminal charges for the act of corruption have already been initiated against all relevant parties. Paragraph D. If the Secretary of the Treasury does not tender these payments within 30 days of the Attorney General receiving the evidence, the amount owed to this person shall increase tenfold. The state shall be liable to that person for the new amount of the reward in civil court. The Secretary of the Treasury shall be sentenced to no less than 10 years in prison with no maximum sentence, and may never again work in any capacity for the government. Notice how I specifically state that anyone who has evidence of a corrupt act, even if they are not personally involved in the corrupt act, can disclose that evidence to the Attorney General. This is intentional. It is designed to enlist the common man into the war against corruption. People currently do not have much incentive to follow their government other than a mere sense of duty as a citizen of democracy. For those of us who live hand to mouth, there just aren't enough hours in the day for us to go and monitor our government. This provision incentivizes the common man to circle the government like vultures, looking for any act of corruption, no matter how small, in the hopes of landing an enormous paycheck. If we combine this with the aforementioned requirement of having the camera footage, keylog records, and phone recordings published online, then that means that we won't even have to get out of the house and walk picket lines to be activists. We can perform the most fundamental and most effective method of keeping the government in line, citizen involvement, from the privacy of our own homes while sitting butt naked in our basements. In addition, the fact that the reward is at least $50,000, but will always be 3 times the amount of the Corrupt Act, means that there will never be any way for any corrupt corporate magnate, no matter how rich they may be, to make it financially worthwhile to not be turned in. No matter how much he offers the judge to rule in his favor, the judge will always get more money if he turns the CEO in instead. Meanwhile, paragraph C provides an incentive to the government to begin prosecuting any acts of corruption as quickly as possible. Since anybody and their mother can turn in a corrupt act for a fat paycheck, the government would be bankrupt in a year on just a single act of corruption if they don't start prosecuting people. After all, if only 100 people turn in a single act of corruption, then the state is now out $5 million, and it will only get worse if they don't prosecute in order to cut off those bounty rewards. The sooner they prosecute, the sooner they get to stop paying random hobos to tell them what they've already heard 1,000 times already. I actually have about 50 different suggestions that could be passed per this initiative, but by now I think you're starting to see a pattern here. Put the burden of complying with the law entirely on the government. Put the burden of showing they've complied with the law entirely on the government. And make the consequences for breaking the law not only severe, but automatic. As I said before, this list of suggestions is not intended to be binding on anyone. What matters is that the government gets reformed. By this point, I hope you all can start to see the sort of pattern I'm recommending here. And I hope you can start to stretch your creative muscles, think outside the box, and come up with some additional laws on your own. But aren't we forgetting something? In Section 3-1, I brought up a good chunk of these suggested laws, and then pointed out how they wouldn't work. Obviously, if they weren't going to work when passed by the legislature, then they aren't going to work if they're passed by an initiative, right? As I said a moment ago, quoting the Mythbusters,
you should never, ever, ever expect Plan A to go off without a hitch.
To fix that, we need a unique safeguard against corruption. One that's never been tried before, and one that is physically impervious to corruption. In other words, it has to be a method of enforcing the law that the government physically cannot ignore, even if they wanted to. If we're going to take the law-making process into our own hands, then we also need a means of taking the law enforcement process into our own hands. I should warn you, though, you will not like the method I have in store for you. This method is one that I would never have suggested unless I knew from years of dealing with these people that there really is no other way. This really is my Plan Z, so named because it is designed to be the absolute last resort. If all the suggestions I recommend in this section still fail, and a person's rights are violated nevertheless, then my recommended Plan Z is Section 3-5, Outlawry. So what exactly is outlawry? What exactly is an outlaw? In 1970, a film studio called Rankin-Bass released a movie called Santa Claus is Coming to Town. At the end of that movie, the main villain, called the Burgermeister, declares Kris Kringle an outlaw.
The protagonists of that movie go into a near panic, acting as if the Burgermeister had played his ultimate trump card. As a child, watching this movie, that scene never made sense to me. Hasn't Kringle been an outlaw this whole movie? What's the Burgermeister doing differently? Well, here's what the Burgermeister was doing differently. Much like the word gay, the word outlaw has been all but stripped of its original meaning. Nowadays, an outlaw is just another word for criminal. To outlaw a particular action means nothing more than to make it illegal. But a long, long time ago, it used to mean something far worse. In fact, outlawry was often worse than the death sentence, since at least with the latter, you knew in advance when your execution would happen and could mentally prepare yourself for it. An outlaw is a person who is outside the protection of the law. The term outlaw is a compound word. By being outside the protection of the law, that basically means that the government will not step in to enforce the law whenever you are the victim, no matter how heinous the crime may be. This effectively allows anyone to rob, assault, rape, or even kill you on sight simply because you're not within the protection of the law anymore. This is why old 19th century bounty posters would often contain the phrase, "wanted dead or alive." Since the criminal was outlawed, it's okay if you have to kill him in order to bring him in to claim the bounty reward. It isn't murder because he was outlawed. This is my recommended Plan Z. If, despite all the efforts we put into eliminating corruption in the last section, the government simply doesn't enforce the law, then the officers who neglected their duty, as well as the officers who broke the law in the first place, would be outlawed. Now, I know there's going to be at least 100,000 people wanting to call me crazy and call me a psychopath for suggesting this. But before you do that, I humbly ask that you hear me out on defending this law. After all, even if you oppose capital punishment in the justice system, you might make a variety of arguments about how expensive the death penalty is, or how we shouldn't stoop to their low to get justice, but you're not going to argue that those who advocate the death penalty are only doing so just because they want to see people die. Same with abortion. Even if you're pro-life, you at least don't accuse the opposition of just wanting to kill babies entirely for its own sake, and have no better motivation beyond that. You give them enough benefit of the doubt that they're at least human enough to not have that motive. Well, I humbly ask that you at least give me that much benefit of the doubt. Now, once you've decided to give me at least that much benefit of the doubt, your next argument against this suggestion is that people will be constantly killing cops, judges, and politicians over the slightest act they personally consider to be corrupt, even if they have no evidence, or even if they have no idea what they're talking about because they're not trained in the law. But we already have a mechanism built into the system that keeps that from happening. Remember, there already is a circumstance where the law recognizes a right to kill. It's called self-defense. So I ask you, if your suspicions were anything other than baseless fear-mongering, why don't people just go around randomly killing anyone they don't like, and then just casually mentioning the self-defense argument whenever they're caught? The obvious answer to that is, they know they aren't going to be set free just because they claim self-defense. The defense has to actually hold up in court. Suppose you have an argument with somebody at a bar, and then you go home, get a gun, return to the bar, and then shoot him, and then claim that the shooting was in self-defense.
Well, as it turns out, the law doesn't give you the right to self-defense in that case. Unless you're in your own home, you have to try and flee the scene before you resort to self-defense. Only when you're in your own home would you be allowed to stand your ground and fight. Oops, sorry, my bad. Now I know. I won't do it again, pinky swear. Except, nope, that's not how it works at all. It's too late for that. You already went and shot the man. Well, outlawry would work the same way. It wouldn't be like judicial immunity, where all the defendant has to do is casually name-drop the defense, and all of a sudden the court would be powerless to assert any authority over him regardless of the rest of the circumstances of the case. Just like self-defense, outlawry would be an affirmative defense to your crime, not an absolute bar to the court's jurisdiction. You only get to use the defense if a jury of your peers agrees that it is warranted on the evidence. And if they don't agree, then you're past the point of no return already. Like I said before, you can add or subtract from my recommendations at will. So if you want to go the extra mile, we can also include various other procedural barriers to prevent aggrieved people from just casually murdering cops and judges before raising the outlawry defense. For example, we could require a person to make some reasonable attempt to resolve the issue using existing means before resorting to killing or pillaging the government officer. However, if you go that route, I highly recommend against requiring them to exhaust their administrative remedies. After all, as I pointed out in Section 1-4, that opens the floodgates for the government to have secret appeal routes that only the most closely connected government officials know about, and then using the fact that you didn't know about those top secret appeal methods in order to arbitrarily block your claims. If you want to require people to make attempts at resolving the issue peacefully, you should make it clear that they are only required to make a reasonable effort to resolve the dispute peacefully. But there's still something missing. Sure, these officers might be outlawed, but if you go and do something to them, what's to stop the rest of the government from just throwing you in prison for it anyway? The best way to ensure that doesn't happen is to make it so that there are no writs of outlawry. No government official, judge or otherwise, should be solely responsible for declaring anyone an outlaw. Doing that would essentially be the equivalent of placing the power of judge or prosecutor discipline in the hands of a single body, and we've already discussed in depth how well that usually works out. Instead, outlawry would have to be an affirmative defense, just like self-defense. You raise it after you get charged with the crime. Then you present your argument to the jury, and they, not the judge, get to decide whether your victim was actually outlawed or not. So, here's my proposed text for this section of the initiative. Paragraph A. Any government officer who violates any provision of this Act shall suffer Class 1 outlawry. Any government officer who commits any other violation of the law that does not specify any penalty for its violation shall suffer Class 1 outlawry. Any government officer who commits any violation of any law while in his official capacity but does not suffer whatever consequences the law purportedly subjects him to shall suffer Class 1 outlawry. Paragraph B. Any government officer who attempts, successfully or otherwise, to enforce the law in favor of an outlawed victim when the law enforcement official knew or should have known that the victim was outlawed shall suffer Class 2 outlawry. Any government officer who attempts, successfully or otherwise, to protect a person they know or should have known to be outlawed shall suffer Class 2 outlawry. Paragraph C. When a victim is outlawed, this is an absolute defense to any crimes, torts, or violations of law in which that person was the victim. When a defendant asserts that the victim is an outlaw, he must, within 30 days after asserting this defense, state with reasonable specificity the grounds for the outlawry. Whether he has done so shall be for the determination of the trier of fact. The burden lies on the prosecution or plaintiff to prove, by preponderance of the evidence, that the victim or plaintiff did not perform the acts or omissions which the defendant asserts constitutes outlawry. The trier of fact shall determine if the acts or omissions alleged constitute outlawry as a matter of law. All parties may provide the trier of fact with copies of relevant law, but the trier of fact shall not be bound by any instructions from the parties who normally tries the law. The judge in all jury cases shall inform the jury accordingly. Paragraph D. The defense of Class 1 outlawry is barred if not raised by the defendant within 30 days of entering his plea or has appeared in the civil action, whether this appearance be by filing an answer, a motion to dismiss, a motion for extension of time, or otherwise. Whether it is timely raised shall be for the trier of fact to determine. Paragraph E. The defendant, upon pleading outlawry, in all cases, shall have the absolute right to present any and all evidence he wishes, regardless of admissibility under the rules of evidence, including, but not limited to, rules requiring the evidence to be relevant to support his claim of outlawry. The prosecution or plaintiff shall be restricted to what is otherwise admissible under the rules of evidence. Nothing in this provision shall be construed to prevent the prosecution or plaintiff from arguing to the jury why the defendant's evidence is not probative. During the outlawry trial, the defendant shall be permitted to offer evidence first. In no event whatsoever shall the defense be interrupted while he is presenting evidence to support his claim of outlawry, except to the end the business day as outlined below, or in the event that an emergency requires the evacuation of the courthouse. Paragraph F. During all proceedings, whether criminal or civil, where the defendant has pled outlawry and that plea has not been adjudicated, there shall be no time limit for the defendant to present evidence. No party in any proceeding where outlawry has been pled but has not yet been adjudicated shall be held in court except between the hours of 8 a.m. and 12 p.m. and the hours of 1 p.m. and 5 p.m. Nobody may be held in court on Saturday or Sunday. There shall be no maximum number of days for the defendant to present evidence. Paragraph G. Whenever a government officer has suffered Class 2 outlawry, they shall suffer all the penalties associated with Class 1 outlawry except as herein provided. 1. The factual allegations given by the defendant for Class 2 outlawry must be disproven or refuted beyond any reasonable doubt. 2. The defense of Class 2 outlawry may be raised at any time at all, even after judgment is entered, and even after the entire judgment has been fully executed. Paragraph H. The outlawry trial must be entirely separate from the remainder of the proceedings and tried by a different jury. In no event may any events during the outlawry proceeding be admissible for any purpose during the remainder of the proceeding. Paragraph I. Upon finding that the victim has suffered outlawry of either class, the defendant shall be exonerated of his charges even if he had been convicted of them previously. However, if the jury determines that the victim was not outlawed, the prosecution or plaintiff may proceed to discovery and trial against the defendant. The defendant, however, shall have the right to take an interlocutory appeal on the adverse jury verdict on the issue of outlawry. Paragraph J. In all cases of outlawry of either class, the defendant shall be entitled to dismissal of his charges if the trial to adjudicate outlawry is not brought within 90 days of the defendant raising the defense. Paragraph E is designed to ensure that a corrupt judge does not forbid the defendant from offering evidence that he knows will work in the defendant's favor simply by coming up with some sort of contrived excuse about it not being relevant. The part where the defendant can present evidence without interruption is designed to prevent the prosecution or judge from not letting the defendant get a word in edgewise and screwing up the defendant's carefully planned flow. Meanwhile, paragraph H, having the outlawry be contested in a separate trial than the rest of the case, helps to ensure that the two juries don't get confused about the evidence and issues. It also ensures that a defendant can show evidence without fear of it being stricken, while still having to follow the rules when his actual crime is being tried. So why is this necessary? This is undoubtedly an extreme measure. As I said at the end of the last section, this is Plan Z. It's the absolute last resort against corruption. Nearly every other method of keeping government corruption in check has been tried up to this point. None of them have been able to curb corruption even slightly. States have passed amendments to their state constitutions, creating separate bodies for disciplining judges and prosecutors, only for those separate bodies to become just as corrupt as the judiciaries and criminal justice systems they're supposed to be keeping in line. Attempts to raise awareness of this corruption have either resulted in them being persecuted, or at the very least, simply being brushed aside as not being trained in the law, while those who are trained in the law and agree with the protesters are stripped of their law license. Even those methods that do work tend to only work temporarily, and only on a case-by-case basis. The people just don't have enough hours in the day to monitor the government closely enough to keep them in line that way. Unless they're being paid to do so, but they aren't being paid to do so at this point in time. Since the people don't have enough hours in the day, neither does the press, since they rely on people reading the stories, not just buying them. I swear to you that I wouldn't be recommending something as extreme as this, except as a very last resort. You guys are coming into this problem fairly recently. Most of you probably had no idea the corruption was even 1% as bad as it is before you started watching this video. So you probably haven't had time to let it all sink in. I, on the other hand, have been dealing with this corrupt government for several years now, and I can personally tell you that every other option has been exhausted. It is last resort time. Now, I'm a fair man. I am open to suggestions of something less extreme that will get the job done. If anyone out there has an idea of what we can do in place of outlawry, then by all means get in touch with me. But be warned, any solution you come up with must work consistently, not just 0.4% of the time. Creating new government bodies for the sole purpose of investigating and disciplining corrupt government officials could work, assuming you had a way of ensuring that these new government bodies would actually do their jobs and not become just as corrupt as the JCOs and ACOs of today. The fear of punishment can often serve to deter criminal conduct just as much as the actual punishment, but in order for the fear to be legitimate, people have to believe that they will actually suffer said punishment. If the chance of them suffering the punishment is extremely low, the fear of punishment won't deter them. If you have a way of ensuring that the anti-corruption bodies will not themselves become susceptible to corruption, then why not pitch the idea of applying this method against the existing JCOs and ACOs, legislatures, and prosecuting officers? So, now we're approaching the end of this odyssey of a YouTube video. I hope you found this video informative and infuriating. I hope that some of you will get reform movements started in your states, sponsoring initiatives to reform government corruption without the need of bloodshed or wanton property damage. Like Martin Luther King Jr., I too have a dream. I dream that one day, maybe on my deathbed, I can close my eyes for one final time and smile because I know that government can no longer get away with breaking the law. I dream of leaving behind a world like John Thompson also dreams of.
I think we all need to wake up and say, hold on, time out. You're not going to take my grandchildren or my nephews and my nieces and throw them away because you want them, or because you don't want to investigate, or because you don't want to hear logic, you know. So I think that's what the most important message is, that this is going to affect us all. We better wake up now before it's too late.